lunch motion, my lord.
We will
Medical
take
admission.
it up today, Mr.
Yes.
At the end
Yes.
of motion hearing cases, you be here.
Yes.
Don't go anywhere
No.
else. Huh?
Medical admission, my lord, not yet now.
What admission? Local candidate? Or representation thing, yes.
My lord. Covered by lordship's order, my lord. Lunch motion, medical admission, your lordship.
Medical and not covered the representation.
Your
right?
lordship, sir.
Why you give the order, Mr.
Like,
How many cases you are getting? All right.
medical admission, my lord. I may permit it to lunch motion.
Medical admission. What is local candidate? Give it. Usual order we will pass in all the cases. Get the madam list and call it some ask us get the list as early as possible because all these cases certified copy have to be delivered today. Yes. DRT?
Yeah, deputy got for extension of entry power.
DRT?
Yeah,
Debt recovery tribunal?
that required.
So against what order have you challenged here?
We have challenged the DRT order for payment of the amount within the stipulated time. We have filed
So
a
appeal lies against that order before debt recovery appellate tribunal?
So we have filed a
We will pass an order just now. If you are ready.
extension of entry
No,
power.
no extension.
Kindly post it for tomorrow. We'll submit it all.
Tomorrow is a holiday.
I mean,
There is no question of Mr. You know we have taken consistently, we have taken Satyavati Tandon and subsequent decision of Supreme Court in 2021. Alternative remedy in case of a physical statute, you should avail of. Otherwise, what is the use of enactment of SURFACE Act? No need of appointment of the debt recovery tribunal. No need of appointment of appellate tribunal. If you don't want to go there,
set of disposition only. Kindly post it for tomorrow.
whatever disposition, a remedy of appeal is there. Friday. 1 minute. You are a student. Are you a student?
No.
We are asking him.
No,
Then
So
what is you see that these students are flocking to the court for this thing orders and medical admission time bound process. Now you can wait till Monday if nothing is happening. It's an old matter.
exactly, Lordship. Notice has been ordered on filing number, but the date was not given for the listing.
No, what is the urgency as on today, Mr.? Nothing. No urgency. Wait. Friday you can mention or
Yes, Lordship.
Monday you can mention. Please mention. Yes.
Matter pertaining to public service commission, my lord. Exam.
No urgency today, Mr. You see medical people, are you a MBBS NEET aspirant?
No, my lord.
Then you can mention Friday, no?
Number 31.
No, you can mention Friday. 31 or whatever. This is all, I mean, taking advantage of no mention day. Suddenly I remember today is a no mention day. That's why.
Medical admission.
Friday.
Medical admission, my lord.
Medical
Lunch
admission.
motion. Obliged.
What admission, Mr.? You only say medical admission and management quota. What? This
Competent authority quota, my lord. They are not considering for
competent means what? Management quota.
not management.
11 seats.
My lord.
What is competent authority quota? We are asking a question to you. Please answer.
Lord, she is eligible, my lord, for the
What is competent authority quota? How is it defined under the
NRI.
rules?
competent authority quota is, my lord, NRI quota.
NRI quota. Read the rule.
I'll
See how casual you people are, just like drafting. Yes.
Lordship,
Pharma.
lunch
Copy
motion
paste
pertaining to medical
petitions are
admission,
being-
lordship. Medical admission,
What admission?
consider represent.
What local candidate? Yes. All right.
This matter, your lordships have.
Medical admission.
No, my lord.
Then wait Friday. Friday you can do it.
The lordships have assigned this matter to Millard, court number 9. Today, Millard, court number 9 is on leave, Millard. It is
Assigned.
to
Who has assigned?
The lordships, Millard, this matter was not before in court 29. The lordships, Millard, have allotted this matter.
Hey, what is the urgency? Your building is being demolished. You are being hanged. What is it? Tomorrow, today at 12 o'clock.
It's coming up before the trial.
And nothing happens trial court. We know how what happens. It will come up on Friday.
Subject to your lordship.
Mr. Reddy, see that this petition comes up on Friday. Give the number, mister. Another bench, you see that it comes up.
We could quote 4 million.
Whatever it is, mister, it will Friday, it will come up.
My lord, I may be permitted to make a mention, my lord. Item 100 is also medical admission, local, non-local.
We will decide it. 100 is what?
Yes, sir. 101 also, Lordship.
100.
100 and 101.
100 and 101 is what?
Local and non-local in medical admission.
100 and 101. Where is the order, mister?
100.
Where is the order in your petition? 100, item number 100. Give the order on which the, show it to Mr. Rao.
I filed my documents, Lordship. Straight.
No, it will be called. It will be called. Nobody should be taken by surprise. Nothing. It will be called. Don't worry.
Your lords, may I please your lordships? Your lords, out of list mention your lordships. Matter.
No. We have stopped this out of list. Acha means mention. What is it out of list?
My lords, it's a Surface Act, your lordships.
Ready with the matter?
No, your lordships.
How you are mentioning the matter? Court is ready to hear right now, and you are saying I am not ready. Then how are you? The moment you move a mention memo, you should be ready to argue the next moment.
My lords,
What order have you challenged?
my lords, an advocate commissioner has been appointed in this matter to break open the seal of the business property.
Then section 17.
It may be posted on Friday.
No, nothing. Not posted today itself. Get it listed. Yes. What order have you challenged?
My lords, an advocate
This is
commissioner has been.
registered. This numbered petition.
Yes, your lordships.
Numbered. Give the file. Not you get it the list. We are disposing it off. This is because of extreme urgency in the matter. This is a measure under section 13(4), correct?
Yes, your
Appeal lies Satyavati Tandon 3-judge bench. What is your answer? That is the order, mister, we are passing. What do you think? We are allowing your writ petition.
No, your lordship.
No.
As there is no stay in the
No
trial.
stay, file appeal before DRT. That is what Supreme Court says. 3-judge bench of Honorable Supreme Court says. File appeal before Debt Recovery Tribunal. This is not forum shopping and bench hunting. Give it.
My lords,
This
I'll
appeal
complete-
has been filed. In this petition. In this, mark the presence. Mr. So and so heard on the question of admission. Get this listed in this writ
Lordship,
petition, comma.
I'll
No,
mention some
nothing.
other day, your lordship.
No. The order will be the same if for some other day also. This, because law does not change. Satyavati Tandon, we are told, will not going to be reviewed in 3 days.
Yes.
So this is what we have done previously also, right? This petition under, see, Mr. all of you know, Mr. Counsel, all of you know the position of law. It cannot happen that you have not read Satyavati Tandon. 3-judge bench article 141.
Yes, sir.
And thereafter 2021, you know it.
Well,
Despite that, you take chances by filing. But yes, people have stopped filing here now because so long as I am there, they have stopped filing because we are bound. We are following every case. We can't this thing take a different view and some other case ask them to file remedy. Nothing. It can't happen. In this writ petition, comma, the petitioner inter alia has assailed the validity of the order dated 15/5/2020-23 by the passed by Chief Judicial Magistrate Ammam,
Yes, sir.
Ammam in exercise of powers under section 14. Madam, section 14 of the Surface Act. The Honorable Supreme Court in so and so paragraph. We have heard learned counsel for the petitioner at length. Paragraph on order section 14 is applicable under section 17. The Honorable Supreme Court in so and so. Not Satyavati Tandon, madam. You got it? No. Honorable Supreme Court in so and so versus so and so has held that even against an order passed under section 14 of the Surface Act, comma, an appeal lies under section 17 of the Act, paragraph. The You will get it or not? See, this is all dictated, right? It's not something new I am telling for the first time from the South Pole. This all is, you people have taken dictation. Madam, this is, you must have a copy. This is not like. Then Satyavati Tandon, where is Satyavati Tandon? Satyavati Tandon. Ah, 14. Keep it here, right here. Nobody will know what is. The Honorable Supreme Court in so and so, right? This is all, you are giving same order, madam. The 2 copies, same order. Section 14 and appeal lies under section 17 of the Act. Full stop. Paragraph 5 and 6 of this WP 20342/2023, right? Para 5 and 6. With the line below, with the aforesaid liberty, the petition is disposed of. This is not the order. Call Rahul. This all. Or Sarita, madam, or somebody. Against an order passed under section 14 of the SURFACI Act and appeal lies. This we have already held, madam. She is unable to get it, giving 2 copies of Satyavati Tandon. After you write section 14 so and so with the aforesaid liberty, the petition is disposed. Certified copy today.
Published notes.
Your copy. It will come up formally in the list and right. Get it in a supplementary list. It's disposed of. All. Next. Yes, is number 1.
Senior counsel is virtually logged in.
Huh?
Senior counsel, Mr. P. Sriragram.
May it please, Lordship?
Yes, please, Mr.
Lord,
Mr.
the petition is against an order of the commercial court, my lord, returning our 34 application on for want of limitation. On 2 points, my lord. One is that we did raise the point, my lord, that section 5 applies, which I am not pressing. My lord, that is not a.
That's what we were about to ask you. That how can you say that beyond 120 days it can be prevented?
That is, my lord.
We appreciate this.
Second point, my lord, I want to, my lord, press in. That is, that also may look little technical, but my lord, that position of law is made clear by the Supreme Court that this particular award, which was passed, my lord, on. I gave the list of events and also a few judgments, my lord, to the lordships. In the list of events, item 11.
Senior counsel, once the challenge to the award is barred by limitation,
yes,
what can be done?
What happened is in this case,
it may be, you may be correct in saying whatever that the award is illegal, couldn't have been passed, but we don't have power to the court.
There are 2 points. First is, my lord, section 5 was filed, that is rejected. There is no case for us. Second point is that this award of 31/12/2021 was, my lord, taken under section 33 application on 22/2/2022. So there was, my lord, an application.
Award dated 31/12/21 was what?
Was the original award, my lord. Then the application 33 was filed, my lord, by the respondent. However, the tribunal did not agree with the respondent's application 33, but made an observation, my lord, while rejecting the application, made another paragraph saying that there are certain corrections to be made in the award. So, my lord, Suomoto made a correction on 28/3/2022. While making this correction, my lord, which would be like a correction to the award, they should have complied with section 31. Lord, that is what the apex court said. Lord, when they have not communicated that by after Lord carrying out the amendments, but only communicated through email. saying that this has been carried out like this,
Hmm.
without following 31. Then, my lord, our contention was that since 33 application right or wrong is there, it has to be complied with under 31. Non-compliance of that amendment under 31, my lord, would not make the award, my lord, enforceable, and therefore, my lord, the limitation would not start running from for 34 application. This is, my lord, the lordship may also view that this we are taking advantage of it because we have filed application much earlier to, my lord, even after the disposal of the amended application. But, my lord, the law as appears, so lordship kindly take the judgment of Justice Aftab Alam, which I filed, my lord, which you lordship will find at page 24.
Where is it, madam?
So my colleague at the bar has given it.
Yes. Which judgment?
Judgment, my lord, of State of Maharashtra versus ARK Builders.
Yes.
24.
Yes.
Page 24 it starts, my lord. I'll just take your lordships to page 30. Paragraph 17. Right side top, you'll also find the page nation.
Yes.
Paragraph 70. In the light of the discussions made above, we find the impugned order of the Bombay High Court unsustainable. High Court is clearly in error in not correctly following the decision of the court in so and so, and in taking contrary view, the High Court overlooked the what section 31(5) contemplates is not merely delivery of any kind of copy of the award, but a copy of the award that is duly signed by the members of all tribunal. In the facts of the case, the applicant, I also read this, my lord, so that I will be on the equity side. Appellants would appear to be deriving undue advantage due to omission of the arbitrator to give them a signed copy of the award, coupled with the supply of a copy of the award to them by the respondent claimant. But that would not change the legal position. It would be wrong to tailor the law according to the facts of the particular case. This judgment has been followed in other case also. So our simple contention, my lord, on behalf of state government undertaking, my lord, is that this particular award for our application 34, unless it is served by the amended, my lord, application and communicate to us in accordance with 31, my lord, it will not come into
Limitation
position.
would not commence.
Yes, I'm only looking at, my lord, the other side to come in so that we can put in some.
No, no, no.
Also advise them, my lord, enforce.
But Mr. Senior Counsel, this was returned not only this time, but several other previous occasions also it was returned, right?
But, my lord, we
What
filed a
happens
memo
to
and
those orders?
yes, that is true.
18, 12, 22, 31, 12, what happens to those orders?
No, but finally, the order is passed on this stage. The order which is now, which is impugned in the revision, is the final order after we filed the memo. This order is the final order.
So this is an order on adjudication, right?
Yes, ma'am.
Ah,
1st March
yes.
23 is the
Yes,
one which
madam.
now I've sent.
All right, all right. Yes,
That's the only point, my lord, I can
all right, yes.
resurrect from this
In
case.
this appeal or Plus IA 2 of 23. Yes. MBBS. Mr. Rao.
Registration,
Huh?
registration, my lord, B and C registration,
What do you say?
management B and C. my lord,
Page 29?
Yes, Lord, 27, Lord.
Page 29 is the order. 27 is cost admin, right? Page 29, madam, certified copy today. Yes. Same.
No, no, say not same.
No, same means representation.
It has go, my lord, it has.
What will be a past and order? Which order?
This order is,
WP number?
item 6, my lord, that is,
Huh?
item 6, my lord, dated for 24496.
244
6 of 23 dated 5/9.
24496 of 23. Same order. This the order.
The orders, they are not imposed there.
This is the order. Please see. Let's see representation thing. He is claiming to be a permanent resident, right? Please see. Right. This order, madam. Mr. Rao. Certified copy today. Yes.
And Lordship, kindly see, my lord, item 10 also same.
10 is also same.
Yes, Lord.
All right.
The local, sir.
10. Same.
Local candidate.
Local. Yes. That representation. Please make a representation certified copy today. Which other case, Mr. Rao?
Only 2 cases, my lord.
Child 100 and 101 not there. All right. Yes.
Item 2, medical counseling.
Same order as that of.
Wait, please, your lordships.
Huh?
I'm representing for the
Yes,
petitioner,
Mr. Rao.
my lords.
Management quota. Which page?
Same item 1 order. This
One.
order.
No, item 2.
Yes, ma'am. Item 2, Lordship, page 27 will is the connected case.
That's in your case, order has been passed, Mr. You have logged in late.
Sir, they have not enclosed a copy of the order. my lord.
Which order?
The same order is not enclosed. in the
Which is that
petition.
order?
Item 2 order. Lord.
Item 2. Item 2 is a local management quota, no? Madam, give a representation with regard to your this thing grievance. The university will decide.
Yes, ma'am.
Same item 8
Copy
also.
in it, ma'am.
Item 8 also.
Oblige.
So what? You are appearing, he is saying obliged. And we don't get
Item
it.
4, my lord.
What is the confusion?
I'm for item 4,
We
my
have told him his item has already been disposed of. He is still saying obliged. We are deciding case, no?
Yes, my lord.
We are deciding your case, right?
Yes.
So item number 2, same order. Disposed of representation you submit. You will apply for copy. You will get it today.
Much obliged, my lord.
This matter, the lawsuits are posted to connected matters.
Corrected?
Counters. WP number.
A list for analogous hearing along with WP number
9291 of 2000.
29291 of
22 million.
2022.
And also 21509, 2 matters.
WP number
21509.
509.
21509 of
21.
21.
Coming up on 14th. 14th.
Whatever, whenever it will come. Yes. Yes, Mr.
Not something.
PG course.
He says, Lord, that he has not.
Original documents in the custody of Ames, Bhopal. So
Last week grant some time, Lord.
nobody is appearing, right? Interim order or final? What we will say that their claim for admission shall be processed, right, to PG courts, and the petitioner will give an undertaking that in 15 days he will furnish all the documents, right? Mark it. Nobody is appearing. With consent, in all the cases, madam, which are being disposed of, you write with consent of parties heard finally. We need not tell every time. This is their standard. In this you will agree that with the aforesaid directions, the petition is disposed of.
And in case he doesn't produce, then seat goes waste, my lord. That is only my apprehension. If in case of his,
See, failing which, failing which the respondent shall be at liberty, respond number 3 shall be at liberty.
respond to it, 2 and 3.
2 and 3 shall be at liberty to allot the seat.
Next meritorious candidate.
To next meritorious candidate. That's it. Accordingly, petition is disposed of. Yes. Password. We are taking it up. Yes. 7, 9, and we are taking up. You please be here.
Okay.
7 and 9. Patch.
Please,
Yes.
Your Lordship. Like to appear, Your Lordship.
Yes.
In not petition is filed in not considering the representation.
Page 20, Mr. Rao.
Yes, Your Lordship. Page 19.
Page 20 starts the order. You are,
It starts from
page
19.
20, Mr. Rao. Please see. Page 20 with consent matter. Madam, page 20 order disposed of certified copy. Yes.
Obliged to.
Yes. 10, 11. Yes, please. Yes, please. So you have. All this. Heard on the question of admission, petition is admitted for hearing notice. A notice has been issued to respondent. He has challenged the validity of a provision. So that
Perspective by this honorable court, full bench of this honorable court,
it has already been upheld.
upheld, my lord. Retrospectivity was also upheld by the full bench of.
Then, so heard on the question of admission, don't admit. Mr. Harinder Prasad Lared, so and so submits that. Yes. 12. Not. None for the petitioner list next week. Yes. That will come up along with that bunch. Item number 7 and 9 and 33 to 77. We will just
Yes, my lord.
finish other bunch and just within
Yes, my lord.
15-20 minutes we will start here.
Yes, my lord.
So others do not wait. That's the idea. Yes. 78. Counter.
Please, your lordships. May it please your lordship.
Until they have been served.
This is that matter about admission of the.
So contempt, they been served?
Yes, my lords, they have been served on them.
All right.
My lords may
Yes,
recall.
who appears? Mr. Advocate General, there is a contempt proceeding against respondents for violating the order. Respondents say we don't know who are respondents. Secretary Ministry of Health, Secretary Ministry of Education, and Sunil Kumar, Director General of Health Services, for violating the order of not providing admission to a third gender.
Sir, you have already provided a seat, my lord.
So you file counter to this contempt, right?
Yes.
Yes.
Notice has been served on you. You are appearing for
No, I'm appearing only for the university, registrar of the university.
registrar. There is no registrar.
Vice Chancellor, Vice Chancellor.
I don't think vice chancellor. Vice
That's
chancellor.
what number 4.
Mr. So who appears for 1 to 3, Mr. Advocate General? They have been served.
1 and 2 are states, third is center.
Well, notice has to go, lord.
Huh?
No.
Notice has been, he
Memo has
says
been
that
filed of service of notice.
memo of notice service has been filed.
My lords, I'll take instructions in that.
Learned.
But the difficulty
Yes.
in the matter is this, my lords.
Hey,
Today, if
this
I-
is contempt. Contempt.
And the writ
Hey,
above.
we have to give them a chance before imposing this thing sentence on them, right?
No, my lords.
It's coming up after notice.
The writ petition and the contempt are listed together today, my lords.
No, we are taking up contempt right away. Last date of hearing 16/8 notice has been issued, and thereafter they are appearing for the first time and praying for time to file counter. We do not know of any procedure which can straightway without filing reply they can be sent to jail.
I'm not even suggesting.
And
that.
that's what
I'm
he's
not-
doing.
I'm not suggesting that. What I'm saying
Much
is
time,
3 weeks, lords, my kindly.
weeks time to file counter.
3 weeks.
Mr. Advocate,
may I make
will
one,
accept notice.
may I make one request, my lords?
In the writ petition, you may make a request. This is contempt. This is contempt, Mr. Counsel.
No, both of them are together, my lords.
No, but we will have to pass separate orders. When we pass writ petition, in contempt, we are giving them time to file counter. In writ petition, you can argue.
Yes,
Ah.
yes.
Yes. So who accepts, Mr. You want?
GP for medical health, your lord.
Acha. What's his name?
Praveen Kumar. Praveen Kumar.
Mr. Praveen Kumar, GP for medical, appears on behalf of respondents 1 to 3. Mr. Prabhakar Rao, learned. Acha, 1 and 2. 1 and 2. Are Mr. Praveen Kumar, not saying anything, you want to go to jail. Write her name, learned counsel for respondent number 3. And Mr. Prabhakar Rao, learned counsel for respondent number 4. Learned counsel for respondents pray for and are granted 2 weeks time to enable them to file counter to this contempt petition list thereafter.
If your lordships kindly.
Which admission has been given where Mr. Rao,
Emergency medicine, emergency medicine.
you have given our admission in
Emergency medicine.
1 minute. We want to note down. We will hear you, Mr. But we want to note down because he has been trying to tell us since yesterday that we have given admission. We are noting it down. Where have you
Given admission in emergency medicine,
Ah.
but ESI hospital.
emergency?
It's a government hospital, ESI.
1 minute. Emergency med. This is admission to PG course.
PG course.
Emergency medicine in
ESI.
PG course in ESI hospital, Hyderabad, and hospital for academic year 23-24. So what is to be done? There is an interim order, right?
Yes, your lordship will kindly see the interim order. It says,
You have filed counter? Counter? Yes. Yes, Mr.
it says this one. In the meanwhile, as and when counseling commences, respondents, more particularly R6, shall
So
extend
which order? Which order are you reading?
20th, June 20th, ma'am.
Yes, yes.
Yes. So if your lordship take the 20th June order, we heard the learned counsel for the respondents at length.
I'm
After hearing the learned counsel for the parties, the state government as well as respondent number 6 and 8 are directed to extend the benefit of third gender status in addition to her status as scheduled caste candidate while considering her admission in any of the courses under the central quota or state quota for NEET PG in a manner beneficial to her. So the three tests are this. First, you must consider her both under the category.
No. So, Mr. Senior Counsel, we have understood that according to you, this interim order has not been complied with as is.
No.
Therefore, be contempt.
No,
Therefore, they need to file a counter in this case also. Mr. Rao has not filed counter.
No, my difficulty is this.
We can understand that still you want some subject of your choice and your institution.
Not only that, not only that. My other problem as of today, the emergency today is this. The seat that they have allotted to me is in a which is not as I am entitled to a better seat. That can brook a delay for
Which?
education.
No. Which course you want admission?
I'm gynecology in one of the government hospitals.
Which hospital?
Gandhi.
You should also choose, right? You should choose the hospital.
I've chosen Gandhi.
Let's see.
I've given them the preferred universities list.
Your candidate is a transgender.
One minute, let me finish, Mr. Prabhakar.
Yes.
I don't know in which century the university is living. It informs us saying, you're transgender, therefore you can't be a gynecologist. This is in the teeth of the Supreme Court judgment.
It is not contention, it is not my concern. I did not even say that she is not entitled. Just I am submitting the honorable court that she is a transgender.
1 minute, wait, let him complete. So, where do we get it that, and where is the application seeking admission in gynecology in government medical college? You are arguing, where is that? Who told you? When did they tell us?
Page 12.
Which IA?
IA3.
There has to be an application, right?
IA3.
It is listed for orders on IA3, right?
Yes.
So we are hearing you on IA3. 23.
Madam.
Where is IA3, madam?
My lord, there is also an IA5 for receiving additional documents.
What is IA3? The IA3 is for implement.
No, IA5, I'm sorry, I beg your pardon. IA5 was for receiving additional documents.
No, prayer that you should be admitted in gynecology course in Gandhi Medical College.
No, my
in the absence of this prayer before us, how can we decide?
My prayer is for admission in a course of my choice. And my list that I have.
No, but Mr. One thing we want to understand, both of us, that this is all governed by merit. Being a person and everything that entitles you to reservation. You cannot say merely because you belong to a particular category that I want to be something else which I don't deserve.
Not at all correct.
This is all governed by merit.
Correct. No,
first of all, Mr. Senior Counsel, our difficulty is twofold. There is no formal application seeking this thing. Only you are making submissions. There is no this thing, and there is no material to place on record that as per your merit, you are entitled to a seat in gynecology, and person less meritorious than you being given admission to gynecology course. This is twofold difficulty. Please address and then proceed.
Your Lordship may kindly take my prayer in the interim prayer that I sought.
Where is?
Page 17 was the interim prayer.
What can be done?
My lords, the gravamen of my writ petition is that
No, we are, Mr. Senior Counsel, we are dealing with your prayer for admission to gynecology course in Gandhi Medical College at this point of time.
What
Otherwise, Mr. Rao is praying for time to file counter.
I have
No,
no
we are not, we are hearing this and ad interim direction. We just told you two contentions. Even if an oral prayer can be entertained, even assuming that an oral prayer to admit you to any course of your choice, everything can be entertained, then also you are under an obligation to show that the candidates less meritorious than you have been admitted to that course gynecology in Gandhi Medical College. What is the material?
may I now respond?
Before we issue a direction to respondent to admit you to that course. This
May
is
I-
what you want today, right?
No,
That
may-
you should be
that-
admitted
no,
in
that is not
gynecology
what-
course in
that is not what I want, my lord. That is not what I want.
then which is what then are you
What I'm saying
arguing?
is this. What I'm saying is they have given me admission in ESI. Today is the last day. If I do not join the course today pending the writ petition, I will have to pay them 50 lakhs under a bond given to them.
That
Therefore,
requirement can be, you are before the court, petition has been entertained, interim orders granted in your favor, you can amend the petition. We can set aside this requirement.
Obliged.
This thing, they don't, orally seek assurance from us and say that the court said that we will struck down. When an appropriate, when a prayer is made before us, we will deal with it.
Obliged.
We will not fall into this trap of oral submission and seeking an assurance. We are not giving you any assurance. When a prayer is made in writing, it will be dealt with in accordance with law. This
I've
is not.
understood that, my lord. I've understood.
Somehow, because Mr. Senior Counsel, we have to be cautious because what he see, we say anything, the counsel say the court directed us to do this. Not supposing if we advise that this happens.
No, for the
I'm
benefit
sure your lordship would-
benefit of my senior counsel, my submission
Huh?
is, for the benefit of my senior counsel, my submission
No,
is,
he is-
she doesn't join, so she is not eligible to participate in the next round of counseling. She has to take admission and to take a chance in the second phase of counseling. My friend says if he doesn't join, blood in the ESI hospital where she was allotted,
They know it, they are litigating, right? What can be done? He is so competent enough to advise. You tell your friend, senior friend, what is to be done.
I wanted,
You just give him advice outside, not in here. You advise him what to be done.
But I have filed the counter.
What do you want?
I have sent the counter not to file not some time.
Counter you have filed?
Not filed.
Mr. Rao.
I have, some time maybe.
Mr. Rao, please
I'll file my.
learn it. Senior counsel for the petitioner.
If counter, my lord, then
In the
contempt
course-
case has to grant 2 weeks.
A counter counter is separate. That is punishment. This is,
Yes.
she
Because
needs
in
to
the
be
order-
admitted. We'll find out
In
what
the
is.
order that your lordships just now passed,
Ah.
your lordship said a seat in Gandhi Hospital.
Ah.
They request your lordship to say Gandhi Hospital or any other government hospital,
Acha, Gandhi Hospital or any other
any
government
other government college
college.
for gynecology.
You consider, Mr. If it any other government
Any
hospital,
other government will
it's
allow.
not. It's not that necessary
But
for you
it is
to
a-
contest everything, right? If
is a
any
benefit
other
of- it is-
government college, if she is entitled as per merit, we will be more than happy if you say that we have given her admission in gynecology in whatever college.
Obliged.
This is. Yes.
But instead of 1 week, not some more time because we had
They already
yeah,
had
yeah, 3 weeks.
They've had 6 weeks.
So what is interim order is already there. You
Yes.
file some interim application, we'll grant them 2 weeks time. If you want file an interim application, you may do so, 2 weeks. All right. There's no point again, he will seek adjournment, 2 weeks, list thereafter. Yes. What is it?
My lord, 80 to 85 go together.
They have been,
My lord,
80 to 85. Yes, what is it?
my lords were kind enough to adjourn the matters to enable the government to seek extension of time from the Honorable Supreme Court. The Supreme Court, my lord, has granted the extension which I knew today only. I have the copies of the order.
So what is?
If my lords are kind enough, kindly take up the appeals after 2 weeks, my lord, we'll argue the matters.
All right.
After 20
Learned counsel for the appellant, 80 to 85. Learned counsel for the appellant submits that Honorable Supreme Court by an order dated 1/9/2023 has extended the time
Fixed for filing the
fixed for filing
writ appeals, present writ.
filing the writ appeals by an order date time fixed by the order dated 5/1/2023 fixed in filing the writ appeals. Full stop. He, however, prays for short accommodation to enable him to place on record the copy of the order dated 1st of September 2023 as by Honorable Supreme Court. List.
It's an extent.
2 weeks, Mr.
They
Senior
can-
Counsel. Yes.
They can go on merits, my lord. Now the delay is condoned.
Yes.
Very well.
So then, Mr. Delay has to be condoned, right? Correct? He's right in saying.
Formally condoned, my lord.
Condoned,
Delay is condoned by the-
IA has to be condoned delay. So then, right, madam, every case heard on IA in view of order passed by Honorable Supreme Court. Delete, place for is granted. Weeks time to delete. In view of aforesaid order passed by Honorable Supreme delay. Yes.
But I have to file synopsis.
Huh?
I have to file synopsis.
You have to file synopsis.
Yes, sir.
One minute. In that case, this senior counsel was appearing in that case. Yes, please. 86. What?
The petitioners before your lordship.
What is, madam? Give file. 86. What is for admission, right?
The question is, whether the petitioners at the office.
No. So 1 minute. You are retired people seeking benefit.
Medical attendant.
Yes.
Sir,
1 minute.
My lords, I am appearing for the first respondent, my lord.
You are granted time to examine whether benefit can be of that hospital.
My lords,
Karnataka Tarnaka Hospital can be given to the association.
My lords, I
You
verify
want
with
to
the,
file counter?
I filed counter affidavit, my lord. Along with that, a specific letter, my lord, addressed by the second respondent stating that they have established a dispensary here in the hospital at Hyderabad. So they are taking care of their all the employees. My lords,
Including the petitioner.
yes, my lord. Page number 13 is the,
No, my lord. Yeah, the hospital, what is
Then it has to be heard in a proper way, right? And then let them file counter, we will hear it. Can't be like this. We'll admit it. Heard on the question of admission, admitted for hearing, counter if any on behalf of respondents be filed within. Counter be filed thereafter, you can move, please. You can move the court. Yes.
Wait, please. My lords, I filed a brief note on last occasion. My lords had asked me what this matter is with regard to the interference of government in the decision making of endowments tribunal. The specific rule has been challenged. Rule 20.
Validity of rule.
Yes.
This requires consideration.
Consider. Your lordship,
Not
that's what
this.
was observed.
You understand, right? Mr. Rao is waiting for students.
Yes.
Right?
Agreed.
Not today, some other day.
Any day convenient. Your
1
lord.
minute. Yes. We have given 2-3 dates in fixed matters, right, madam? Do you remember? 14th September, we have given you, people have not noted down that this thing, Mr. Vaidyanathan's case, we have fixed some bunches, we have given dates.
Right.
You should make note of, if we fix it on that date, it will never be taken up. Third October.
Yes.
Yes.
Public.
Petition is admitted for hearing.
Entire
Petitions are admitted for hearing. Let the same be listed on 3rd of October 2023.
Public.
That is
87 to 99.
60
Yes.
to 99. Yes, ma'am.
Yes.
May it please your lordship. My lord, I am appearing for the petition
Ah.
in this case, my lord, on the
You
last
are
occasion.
mentioning at 10:30.
Yes, yes, my lord.
We had assured you that number would reach.
Yes.
Yes.
On the last occasion, I had.
Same order as item 3, lordship.
Same order
My
as
lord,
item.
for a moment, item 3 is for representation.
Yes, yes.
No,
My lord,
representation.
this matter was filed.
Otherwise, we have another order.
No, no, my lord, I may be permitted to make a request, my lord. This was filed on 31st
Not
of
request, submission.
submission, my lord. Sorry. my lord. On 31st of August itself, I filed, my lord, due to a discrepancy in the prayer, the matter was adjourned, my lord. If not for that, my lord, it was filed somewhat within the time, my lord.
There is no limitation, right?
Yes, my lord.
Article 2 to.
And on that day, my lord, certain.
Please sit down, madam. We are unable to see Mr. Rao. Why you stand up after between 1:30 to 2:30 and after before 10:30 you come and stand up all the time. We are unable to see him. Then 4:45 till whatever time you want, you stand up. Don't in between. Yes.
Yes, my lord. On the day,
No, Mr.
on the same day, my lord,
One minute.
certain match was allowed. my
No,
lord.
no, not what same day. This order, please see. This is the order we have already passed. And we cannot take different view if you are seeking admission today. This is the order you will get. Otherwise, consideration of these are the two options possible.
My lord, my respect.
Please, no, read it, Mr. You should have read it before arguing the case, but we are being this thing advising you to take this thing action. At least the legal position, not like this. Go through we have referred to 4 Supreme Court decisions and decided it. This is fence sitting, no limitation.
My lord, then I'll
This
take
order,
it. Understood.
will pass an order.
No, my lord, not this, my lord.
Give
Representation.
that file.
Representation. Considered. I understand your. My apologies.
This is conduct of when sitting. Others, you were declared as non-local candidate on 2nd August. 31st August, you have filed the petition. They have to complete the process of admission. It cannot be that all along we entertain the petition and give them directions.
Understand.
So which is the item number?
Item 3, Lordship. Item 3 today.
Item 3 disposed of certified copy to. Yes.
Much.
Next.
It's also same, Lord. It's also same.
Same.
Please, Your Lordship. I filed for the registration application for the category B in 4th August, Lordship. I filed my additional documents.
So we asked you, when were you declared non-local?
No, you wanted your reservation.
I was declared as in local.
Management quota 85% reservation. Let him make a representation, university will consider.
Yes.
Where is the order?
My order is 22038.
There is no order deciding similar rate petitions, Mr.
Similar rate.
You are not the first person.
This Honorable Court has not disposed of similar petition.
Yes, sir.
Lord, you wanted B category seats. Only 85%.
In this, mark the presence, the petition.
B category.
Mark the presence, petitioner is an aspirant for admission to MBBS/BDS course. So this is item 13, right? 13, what we have done? 13 same. This is it has to be taken up. 102. This is along with Mr. Rao's case. 102 along with Mr. Rao's case.
Yes.
Same.
Yes.
100% reservation. Yes. 103, madam.
Right, please. No, she challenging the non-appointment of the president to the consumer commissions in the state commission.
Mr. Advocate General, what happened?
The post, my lord.
You said that we will fill it up. Last date we were in, Mr.
My lords, in fact, we are going to, my lords, move the Honorable Supreme Court for a clarification because the notification which was earlier issued, my lords, subjecting a retired judge of the High Court to an exam, my lords, we are requiring, my lords, the Honorable Supreme Court to look into that aspect. If within 2 weeks or so, my lords, if we don't succeed, my lord, we'll have to go with the notification as decided by the Honorable Supreme Court. That is the, Lordship may consider a party.
14% Learned Advocate General submits, 1 minute, Learned Advocate General submits that that state government has filed.
Moving, my lords,
Is intending to move Honorable Supreme Court for seeking clarification with regard to the order.
With regard to the notification, my lords, orders of this honorable Supreme, my lords, the notification was issued
Notification
for appointment of, my lord, the
for notification issued for appointment of the president of
President, State Commission.
State Telangana State Consumer Disputes Redressal Commission. It is further submitted that in case the state government is unable to seek a clarification from Honorable Supreme Court, the notification dated notification issued for
My lords. Yes.
fresh notification.
Fresh notification will be issued in terms of the guidelines frame.
Yeah, a fresh notification for filling up the post of president in Telangana State Consumer Disputes Redressal Commission shall be issued. What do you say?
My lords, already a review is filed by some other state. Honorable Supreme Court has dismissed that review.
No, the review is moved by the government of India. That is that on a different aspect, my
But
lords.
that was dismissed by Honorable Apex Court on all counts.
We are seeking not review, clarification. We don't know what is the clarification. This is a public interest litigation, right? You get a lot of consumer complaints, right? So therefore you want president to be appointed. Lot of consumer complaints, not being decided.
Lot of pendency is there, my lord.
That's why. That's why we could gather that you are getting lot of consumer cases.
Oblige. Oblige.
142,
Restricted to
111.
Wait, please, your last.
Yes, please.
There are two applications are filed in commercial court appeal
Ah,
number
for 2
3 of
weeks.
2019.
Date will be given by the system. Don't give dates. List after 2 weeks. What is IA?
Yes, my lord. IA 1 is for granting leave to substitute the name of the liquidator, my lord. In
IA
place-
1.
Yes, my lord. To substitute.
1.
Yes, my lord. 1 of 2023.
Yes, any objection?
In this regard, I do not have any objection. I do not have any objection with regard to action of 1 year.
Hold on,
Petition
IA.
of liquidator. I am instructed to appear on behalf of the liquidator.
This is leave petition 1 probably.
Yes, my lord.
Hmm?
Leave. IA 1 of 2020.
What is leave?
Leave to substitute the name of the liquidator.
Oh, leave.
In place of the.
Acha.
Yes.
Heard on IA 1 of 20, mark their presence, heard on IA 1 of 23, an application seeking leave of the court to substitute the name of the liquidator after hearing learned counsel for the parties and for the reasons assigned in the IA.
Are now entitled to receive an amount of rupees 70 lakhs odd rupees, 1 crore odd from the credit of the EP. And as in the very same order, it is
You
also
are a
directed.
decree holder.
Yes, he is the decree holder, I am the judgment debtor. And also permitted the
So
judgment debtor to.
63 lakhs, why he can't be permitted to withdraw, you tell us.
No, in the order, the Honorable High Court has, permitted the judgment debtor withdraw an amount of rupees 63 lakhs.
Judgment debtor.
I'll submit. my lord.
So, see, supposing if a decree holder succeeds in the suit, the decree holders deposit the amount which judgment debtor can withdraw.
In the order,
This is what you are trying to tell us.
in the order,
Who deposits the amount?
it is not.
Ordinarily speaking, if a suit has been decreed, huh? and an appeal is preferred or something proceeding is carried further, who will deposit the amount? Judgment letter,
Yes,
common sense.
yes, Your Honor.
How can you be deposit the amount and he will deposit the amount and you will be permitted to withdraw?
It is not his deposit, Your Honor.
Your deposit and you have been permitted to withdraw.
It's subject to the result of the appeal. That is what the order said.
But this order was passed in 2019, my lord, when
We are not getting it, Mr.
that's what.
Because it has come up on interlocutory application, so we are not getting it. You are not clear on facts.
Yes, my lord. I'll submit.
You had filed a what? Suit.
Yes, my
You
lord.
had filed a suit
Yes,
for
my lord.
recovery of the amount.
Arbitration application. My lord, are you in the, I got
Award was passed by the arbitrator.
Yes, my lord. Arbitration tribunal consisting of 3 members has passed an award in my favor.
When was the award passed?
Yes, my lord. This award was passed, my lord, on 4/9/2015.
Then who filed a petition under section? This was in your favor.
Yes, my lord. Award is in my favor.
What does it say? How much amount you are entitled to get?
Yes, my lord. It's in 2 parts, my lord. Total 1,55,33,638. That is up to the 23rd bill. And in relation to 24th bill, 2 crores and 25.
1 crore?
1,55,33,638 up to 23rd bill.
Up to?
23rd bill. My lord.
And then second?
Second is 2 crores 25,89,737.
25 lakhs 89,000?
737. That is with regard to 24th bill.
All right. This is the amount you are held entitled to.
Sorry, my lord.
This is the amount you are held entitled to.
Yes, my lord.
Now,
No. Subsequently, my
just a
lord.
minute. Then they filed petition under section 34.
Yes, my lord. COP 98.
Whatever number doesn't matter.
Yes, my lord. They filed.
So therefore, the award has been modified.
They filed for setting aside that award. Award that was dismissed. But I also filed, my lord, under 34, saying that while passing the award, the arbitration tribunal has deducted certain amounts. After arriving the amounts payable to me.
Parties filed under section 34. What happened?
Yes, my appeal, my petition was allowed and their petition was dismissed. But
Award has been set aside.
No.
Allowed means?
No. Their petition to set aside award was dismissed. My application, my lord, seeking, my lord, some part of the award, my lord, where certain deductions made contrary to the agreement, terms of the agreement, my lord.
Part of the claim not granted, they were granted by the arbitrator.
Arbitrator has.
No, Mr. Part of the claim not granted by the arbitrator have been allowed by 34 court, right?
Strictly speaking, my lord, the arbitrator has allowed all the claims. They made, my lord, certain deductions, my lord.
Please understand, we are not deciding this appeal finally today.
Yes, my lord.
It is for withdrawal of permission to withdraw the amount. Since he is opposing, he is saying that decree holder has been permitted to withdraw the amount. Then if he has been permitted, how are you making an application?
I'll submit.
I'll just clarify.
I'll submit, my lord.
Mr. You are here to, Mr. Counsel, you understand, you are here to assess this court. You don't do it, create all sorts of confusion. That's why, I mean, see, it is taking such a long time for decision of IA.
I'll file a detailed count.
1 minute. 1 minute. Why did you not say that you wanted to file a counter?
My lords, I have just received instructions today, Your Honor. I'll file my.
Then you should have said that I have instructions today. Please, I'll file my count. Then we would not have troubled senior advocate. He is also not ready. So why we should have troubled him? Yes.
In a week's time, Your Honor, I'll
Learned counsel for respondent praise fund is granted. 2 weeks time to enable him to file IA, counter to IA. Yes. One word. Yes.
Whether it's appealing director to order single judge.
Yes.
Whether interim order related.
So what is objections not filed counter?
So I reply. I also filed my reply.
Petition is admitted for hearing.
Whether interim
Let the interim order shall continue.
apply.
Yes.
Okay.
Pleadings in the case are complete. Third learned counsel for the parties petition is admitted for hearing. Interim order shall continue. You are granted license in perpetuity or till a particular time?
3 years.
What time it will expire? 3 years? No.
47.
Give the order in that file. Up to what?
His license was expired in the year 2016 itself.
I am the appellate, sir.
So we are asking you, yes. Trade license till what time?
That is for petition case. I am particular. I am not the party in writ petition. But without making me the party in writ petition.
No, there is an interim order granted in your favor, right? So that is granted on the strength that you have a trade license.
But not me. That writ petitioner.
None for the petitioner awaiting appearance of delete everything. None. We were under an impression that you are for the appellant. None.
I'm not party in petition. But I find appeal taking leave of Mr.
No, Mr. What's your problem? We are admitting the appeal, continuing interim order. Still you are arguing.
I'm not getting.
You are having a trade license. You don't have a license.
I got license, but I also authorized by the municipality to collect the waste.
Till what period?
Till May 2025. For 3 years, I was granted license.
Date.
The date. The date led 27/3/2023. For page number 43 in the writ appeal.
Till
for 3 years. 27/3/2022, 3 years. License was granted for collecting waste.
When 3 years will expire?
27/3/2026.
26/7, 26/3/26.
26.
It refers, petitioner means it refers to the appellant. That means appellant.
Dundigal municipality will not come under the GHMC limits, my lord. Dundigal municipality is a separate municipality.
Admitted for hearing interim order shall continue.
Apply.
Yes. Yes.
So R1 to R3 minutes.
Ah.
I appear for R1 to R3.
Ah.
On 5/7/2023, my lord, interim order has been vacated.
5/7/23?
Interim order has been vacated.
No, so what? What is the appeal about? None for the appellant. Hearing is. We thought that you are appearing for appellant.
For our.
Mark their presence, none for appellant awaiting appearance on behalf of the appellant's hearing is deferred list after 2 weeks. Yes.
Right.
My lord, in this batch, the pleadings are complete. Both the states have filed their respective counters. This may have to be.
Appeal is admitted for hearing.
There are interim orders in all.
Petitions are admitted for hearing. Pleadings in the case are complete. Let the same be listed for the interim orders granted on earlier occasion shall continue. Interim, let the petitions be listed for hearing. Yes. Which date shall we fix a date, Mister? You want us to fix a date?
Please, my lord, any date subject after a month,
October.
we'll get ready.
This October we have holidays. No? What?
Subject to my lord's vote.
It can come up on 4th October.
Great.
4th list for final hearing on 4th. Please give us synopsis. Be short. And we are sure very this thing. It can be disposed of, like it can be decided. 4th. Please prepare a synopsis. Don't say start from. Help us. Yes.
Oblige.
Huh? 150. This is 410. Madam, this what you should write. You should write that this batch, as we have given final hearing date, and earlier 3 cases we have fixed already. You should write 14, not 1410, 14:9, madam. And 2 other cases we have given dates. You write it here and tell us that, sir, these cases are fixed for these dates. Otherwise, Disha case also comes, this bunch also comes, nothing happens. You write here, Disha case, this date, this Mr. Vaidyanatھ, this case, whatever this case, that electricity bunch, like. 150.
154.
153. Yes. Yes. No, last date of hearing we had passed an order, right? Preservation and protection of Golconda Fort as well as 27 other state status report.
Government already filed, madam.
No.
Respond number 1, 2, 6, 1, 2, 4 and 6 filed.
What is to be done then? You are the petitioner, right, Mr.
He is the petitioner. I am for the respond number 7 petitioner.
I'm only for the, I'm for the implead petition. I'm not for the petition.
You are, by seeking impleadment, you are prosecuting your own cause, that they be directed to register a deed in my favor by in respect of Golconda Fort, right? Correct?
No, that's not.
What is implead in a public interest litigation?
That's my.
He wants implead petitioner. Will you convey court to him? You will have to ask Mr. Praveen Kumar. He wants implead petitioner wants that it should be conveyed to him. No. Yes. What is it, Mr.? What is to be done?
My lords, I'm appearing on behalf of Mr. L. Ravichandar. He's appointed as an amicus in this matter. Your lordship may have it next week or the week thereafter.
Let the writ petition be listed for consideration of IA2 of 21 after 1 week. Yes. This is final hearing, madam. There is no passover, right? Which case?
They are for 157 and 59.
No. That is final hearing. That will be taken up after this bunch is decided, right? So now only bunch remains, madam. 13. They give her this thing sort of sheet sort of thing. ये शीट नहीं है क्या? निकाल के दीजिए ना, वही तो कह रहे हैं क्या? ये नहीं, ये सब लिखा हुआ है, ये ले जाओ। Hey, Mr. Madam, give some plain papers, like he doesn't have the sheet, we don't have. What is this? No, no, you should, madam. Seven, nine, which, and what are the other cases?
13 onwards.
13 to 77, and which other case? 7 and 9, 13 to 77, and which other case? There was one in between also. One not two. Yes. And your other cases also which you said, Mr.
Yes, madam. That's 29, madam.
Huh? 29?
20.
No, no, you said no, today you have filed.
Yes. 19, madam. 19. The
Huh?
PG admission.
Same, right?
No, the other matters are yet to be placed before your lordship. New matters.
Hey, Mr.
Ballot.
We are trying to ascertain how many petitions, item number 7, 9, 13 to 77,
and
102.
Three more I gave a slip.
102. Which is the petitions, madam? Have you got his petition? Ah. Get it, madam. His. Ah. So your files number, not
Numbers
number.
I have.
Then
I have done.
WP number?
Yes, WP number 24798.
24798. Same, right? Identical, no?
Yes,
New grounds pleaded.
No. 24825.
24825.
825 and 24826. Three matters, all numbered.
24826 of today. So you are appearing in these three rate petition, but and item 7 and 9.
9.
That's it?
Yes.
5 cases.
14 also. 14 the old one. 14 is listed in the batch. 18216.
Mr. Tirumala Rao.
18216.
Mr. Tirumala Rao. Serial number 7, 9, and which other case? 14, and these three rate petition. Right?
Yes.
Numbers of which you have just now given.
Yes.
Please, yes. Have you prepared a synopsis sort of thing?
With your lordship's permission, your lordships. My sincere apologies for appearing online, your lordships.
No question of apology. This is a facility created for you all. Mr. Tirumala Rao, we are hearing, and thereafter you will argue.
Your lordships, I have, if I may be permitted, your lordships, my compilation and the brief submissions may be taken, your lordships. They're there, your lordships.
We will, Mr. We will hear you. No petition can be decided without hearing the counsel. Some other counsel is here in person. He will argue. Thereafter, you will argue. Or who is senior, Mr. Rao? Between the two, who is senior?
It is of course.
No, not up to. We go by order of seniority. Are you senior to Mr. Tirumala Rao?
Rao, sir, your lordships. I will stand by.
No. There is no question of standing by, Mr. Everything is don't come and blame the court for everything. We are asking a simple question to you. Are you senior to Mr. Tirumala Rao?
No, your lordships.
Then will he not have the precedence in opening the argument?
Absolutely, your lordships.
Then Not leave it to just blaming the court all the time. Not good, not a good practice, healthy practice.
Obliged, Lordships.
It's not that we are dictating the order. We are hearing Mr. Rao. We have told you that we will hear you. Your cases can't be decided without hearing.
Obliged, Lordships.
But every time you must do something, right? You can't permit the court to proceed quietly with the case. Some fireworks, huh? Right?
My sincere apologies, Your Lordships.
No, Mr. Improve yourself. You are a young person, long way to go. Improve your mannerism. Right? There's nothing. Mr. Tirumala Rao doesn't want admission to PDS course. His clients want. We also don't want admission to PG course. You also don't want. Our endeavor is to find out a solution to this legal problem in accordance with law. Why personal element and as it pleases your lordship and this thing? Why? You seek permission of Mr. Rao. If he permits you to begin, we will permit.
No, Your Lordship.
Mr. Rao, he is a junior to you, but he wants.
No, Your Lordships. I will do it after Sir is done, Your Lordship.
Then please switch off and enjoy. Yes, we are doing our job. Yes, yes, Mr. Rao. Yes.
Synopsis.
Yes.
But briefly stated.
Have you this thing reproduced the rules somewhere, Mr. Rao? Can we have a look at the rules?
Rules. Start with the repetition. Page 26 of the repetition, item 14.
Why serial number 7 we begin, no?
Very well.
7.
Very well.
We will refer the facts from serial number 7. We will have to refer facts in one case. We will refer from serial number 7. This is like those persons who have done from Russia and Ukraine and this thing.
No, my lord, that is PG admissions, my lord. That's listed as item number 19, my lord.
No,
this is UG admissions challenging 100% reservation, but to the extent of my lord, restricting to the new college.
Mr. We thought that it's same case.
No, 19 is also 100%.
No, then Mr. Rao may not be ready. Then it's a different issue. We were thinking that PG thing, all these petitions are PG.
These are
Undergraduate. You are ready to argue. Then this provision is Mr. 7, 9 and these petitions 7, 9, 14 and 3. No. These issues 1, 2, 3, 6 petitions separate issue, remaining one separate issue. Correct?
But 6 petitioners, my lord, filed before, my lord, your lordships dealt with all those matters and passed an order on 19/8. And interim arrangement was made for in respect of the 6 petitioners. After that, matters came to be filed, my lord, by all the similarly situated candidates.
No. So this is, Mr. Rao, we remember that you argued this. You argued this thing. You argued the case related. You told us that we are Russia, Ukraine, we have passed, and that is.
Yes, that is a PG admissions, my lord. 8
that is a
petitioners were
different
there.
case.
Yes, only one matter. Only one matter, 8 petitioners. That's listed as item number 19.
So this is different.
Yes, this is 72 GO, my lord. 72 GO batch.
You understand, Mr.
Yes,
Rao. What
yes.
we are trying to ascertain is 7, 9 and these 3 writ petitions of which 7, 9, 14.
14.
And 3 writ petitions of which you have number given.
Yes.
This is a different challenge.
72 GO, which your lordship already heard and passed an interim arrangement was made in respect of
This is exactly the same case, lordship, let him come. This is pertains to UG with undergraduate. But the 7 and Tirmal Rao, what? 6.
No. So then these cases are different than 13 to 77, correct?
No, all same, except one case filed by Tirmal Rao with regard to Millard's GOMs number 73 with regard to PG courses.
What is that PG thing, Mr.?
PG, same, my lord, same effect.
No, which case?
Item number 19, my lord.
19. So that is different.
Yes.
That is different.
Yes.
19 is PG and there may be separate rule, no?
Yes.
In that sense,
Yes.
different.
Yes. Separate GO and separate, my lord.
Rules, amendment to the rules.
No.
Like this is GO 72.
We don't know. You go by number. We don't have absolutely any idea about number business, right? We know the rules by their names or the year. Use 74. Appreciate Mr. Rao for the purposes of writing the judgment. We are putting a query to you.
Yes.
Issue involved in item number 7, 9. These 3 petitions of which you have number given 13 to 77, 102 except 19 is same.
Yes.
And they can be decided by a common judgment.
Yes.
102 separate judgment, separate whenever it turns come, we will decide.
Yes.
First, we will deal with this.
Yes.
Correct?
Yes.
That's what 109, item number 19 is different case.
Different.
That's why we asked you, because you have not given any facts here, no? So that's why we remembered that we have to write facts. That's why we asked you, did you pass from Russia, Ukraine? So you say, now understand what would the query.
I'm sorry.
All the time, see, you will argue and get away. But who will write the judgment?
Yes.
The court has to write the judgment, therefore we are ascertaining. So you have not given any facts. Item number 5, 7, 6. You are petitioner in 7, 9, 14 and plus 3 petitions, right? This is pertains to item 6, 7. Yes. What are the facts in 7?
Well, in the synopsis, the last page, your lordships may kindly take.
That's what you should have done, Mr. Rao.
No, I have the dates all recorded, Miller. Last page of the synopsis.
First, you should have given facts, no?
Fourth page. Synopsis, 4th page.
No page.
4.
1, 2. Rules of admission cannot be changed midway.
Yes. 2.
Yes.
Out of that, Miller, academic session commenced. Lord, this is a date, 6/3/2023. This is an NTA exam notification, National Testing Agency.
There is no page number here also.
I'm sorry, Miller. These are 2 different, yes. I have just enclosed. But
I should have asked your colleague to put at least page number. You are referring to 4. There is no 4 number. We have to put the numbers. 1 minute. Yes, go ahead.
Mallard. Academic session alert commenced by a notification issued by National Testing Agency Mallard on 6/3/2023.
Yes.
But applications were received from the candidates from 6th March to 6th April. Exam held on 7/5/2023. Alert results declared on 13/6/2023. But after this, 3/7/23, alert the impugned juror came to be passed, Mallard. Page 27.
What is GO impugned?
Page 27 of this writ petition, Mallard.
Page item 7, right?
Yes. I'm sorry, Mallard. Page 25, Mallard. Page 25 is the impugned GO. GO 72 is dated 3/7/2023. Mallard, there's an amendment carried out to the Telangana Medical and Dental Colleges admissions into MBBS and BDS courses, rules 2017. But the amendment is at the bottom, Mallard, in the said rules in rule 3.
What is the rule which is sought to be amended?
Yes, Mallard. Rule 3, 1 and sub rule 3.
Sub rule
clause A, D and E. The following shall be substituted. I have, Mallard, the very next page is the existing rules.
No.
2017 rules. Yes, kindly see the existing rules, Mallard.
First tell us what was the position under 2017.
17.
How it has been amended.
Yes, page 27, Mallard.
Because see, yesterday, 2 days ago, we heard a bunch in which it was argued that a non-existent provision has been amended. So therefore, we are trying to understand which rule, what is rule.
27 is.
1 minute. So this under section 3, 1 and 15.
Yes.
Of this section 3 and 15, 1 of the act, 15 of the act, the rules, 2017 rules were framed.
Yes.
What was the position in the rules, relevant rules?
Yes. Page 27, GOMS 114 starts, Miller. Page 29. Page 29, rule 3.
Rule 3.
Seats shall be reserved for the following categories in admissions to professional courses.
Rule 3, 29. There is no 29 in this.
GOMS 114 starts at 27, Miller. Page 27. Page 29, Miller. 28, 29.
Please see. Arey, madam, give it to him. Please see the pages. You said 29. I am searching. So, 28 after 31 straightway.
Page number is missing.
So you don't want us to refer to that rule. That's why you have not annexed in the copy of the court. We will say that there is no rule.
मैं पास ऑन सेम रिपीट.
In your copy has annexed.
I'll take it.
Some.
They want you to read the rule. They want university to read the rule, but not the court. I don't know what is it. Yes. 29.
Page 29.
Yes.
Mallard. Rule 3, Mallard, page 29, Roman 3. Seats shall be reserved for the following categories in admissions to professional courses. Region-wise reservation of seats. Admission to 85% of the competent authority seats in each course shall be reserved for the local candidates, and the remaining 15% of the competent authority seats shall be unreserved seats as specified in the Andhra Pradesh Educational Institutions Regulations and Admissions Order 1974, subsequently amended.
Now, what is competent authority seats? It is defined here.
Competent authority seats are Mallard seats, EMR.
Government seats. Government seats.
Yes.
Seats. Page 27. Roman 5.
Earmark out of the sanctioned intake. So basically government seats, roughly we may so.
Yes. Total number of seats in a government college, Millard, and 50% of Millard unaided medical college, private medical college.
All right. So this rule provided, Mr.
Yes.
That 85% shall be local candidate.
And remaining 15%.
1 minute, competent. %15
shall be unreserved.
Unreserved.
Yes, as specified.
So we are concerned only with this clause. Clause A.
Yes.
3A.
Yes.
1, 3A.
Yes. And all the petitioners belong to the unreserved.
So this is not nothing to do with clause B.
No. Yes. Clause A.
Clause A only.
Yes.
Then this was the position.
Yes.
You were happy with this that because you got 15%, correct?
Yes.
Now how this has been altered?
Yes.
By amendment.
In the said rules, in rule 3, page 25,
You make photocopy of one page and
Yes,
give it to me.
Yes.
Yes.
But in the said rules, in rule 3, 1 in sub rule 2A, for clause D and E, the following shall be substituted. 85% competent authority quota are reserved for local candidates.
No. So this C, rule 331A, right, was provided. So what has been amended?
Rule 3.1.
3.1. Mr. C, you pointed out.
Yes.
Rule 331 and A. Right?
Yes.
Was 85%, 15% competent authority. Now this has been amended, right?
Yes, my lord.
So what does this rule
They have
say?
been substituted. The following shall be substituted, namely, instead of A.
Sir, in the said rule, in the said rules in rule 3.1, in sub rule 2, rule 3.1. You get it, Mr. Where is 3.1?
3.1 is
3.1 is definition.
Yes.
3.1 in sub rule 2. There is no sub rule 2. No. Yes. 3. 1. 3.1. 3.1 sub rule 2 reservations. Right? Here is the
reservations. Yes. 2.
A, B, C.
D has been colored.
D and E have been substituted. This is what?
Yes.
So, Mr. You should have read this. You are reading something else.
The geo itself, my lord, I'm trying to understand. It's been 2 months since then.
You realize, Mr. Rao, that you should have read D and E.
Yes.
That's why we are so particular.
Yes, ma'am. D and E. Roman 2, D and E.
Rule 3. Now the amendment. So, Mr. This thing, the earlier provision was rule 3.3 Roman 2 clauses D and E.
Yes.
Right? This was 85% in non-statewide institution, 15% unreserved seats.
Yes.
And 15% seats unreserved reservation shall be maintained for unreserved on total seats available.
Yes.
This was, you were happy with this?
Yes.
Because 15% you were entitled to be considered.
Yes.
Now comes the amendment.
Yes.
Page 25. Now read, what is it?
Lord, the following shall be substituted, namely 85% of seats competent
1 minute.
authority quota.
Rule by amendment, rule 3 Roman 2 clauses D and E substituted. Yes. D
Correct.
provides for now
85% of seats competent authority quota are reserved for local candidates in non-statewide institutions and 15% seats of competent authority quota are treated as unreserved seats in colleges established prior to 2nd June 2014.
We are concerned with this only one.
Yes.
D, clause D and E as well.
As well, and H, introduction of a new clause, my lord.
One
bottom.
minute. Then E is what? 15%.
A new clause.
Ah. Yes.
Lord, after G, after existing clause D.
You are challenging validity of which provisions? Now tell us.
Yes.
Saying generally that old 2000, this thing 17 rules challenge is different from impugning particular. You cannot challenge these rules may be called rules. You cannot challenge that. Right. So which provision you are challenging in this?
The GO was introduced, my lord, amending the existing rule, that is D and E, and introducing H, a new clause H.
So you are challenging clauses D, E and H.
Yes.
Right. Challenge to rule 3 within bracket 3 Roman 2 D and E as substituted. Yes, what is it, Mr. Reed?
Hello.
Now we can proceed faster, having understood basic facts. What
Your
is
time-
3H? 3H, read.
H is in colleges established after 2nd June 2014, 100% of seats under competent authority quota are reserved for local candidates and all applicable reservations shall be implemented.
So you are challenging all these clauses, right?
Yes.
No, or only 32H, 332H.
Yes, 3-2, yes.
No, the confined challenges to 332H, right?
Yes, my lord.
Not 33 D and E.
E and D, D, E and H.
All.
Yes.
All.
Substitution is by way of amendment, my lord.
All. Yes.
Well, kindly, when I take your lordships to the notification, the same GO 72, the notification reads the middle of the GO, my lord. Middle of the GO notification in exercise of the powers conferred by section 3, page 25, GO 72.
No, that nobody disputes the 3.1 and 15.1 of Education Act.
I just want
power is there.
Highlight that. Yes, power is excised under that act.
We know that. We have already held.
Yes. But kindly see the next page, my lord.
No. Now we can go to the challenge, right?
Yes.
Straightway. Oh, anything else you want to point out?
No, just a tiny bit, my lord. The next page, my lord.
What?
Page 26.
26. Yes. Yes.
Again, my lord, the one which I read to your lordships at the inception, Rule 3, Clause A. But again, if your lordships takes 29, 29, page 29,
No,
Rule
you are
3.
challenging this also.
Yes, yes.
So what is this clause?
This is, my lord, the following shall be substituted. This is again a substitution.
No, mister. What is the clause?
Yes. Kindly see, my lord. Admission to 85% to the competent authority quota.
Sub rule 3. 1 minute. Rule.
The entire clause remains the same. Yes.
Rule 3. No, mister, you must tell us where it is substituted.
Yes, the entire clause remains the same. Just the last words, my lord. After 1974, as amended from time to time.
No, which?
3, my lord. Page 29.
3.
3A.
A.
Page 29. This is how, my lord, I was confused and I'm sorry, my lord. 3A, admission to 85% of competent authority seats in each court shall be reserved for the local candidates, and the remaining 15% of the competent authority seats shall be unreserved seats as specified in the Andhra Pradesh Educational Institutions Regulations of and Admissions Order 1974, subsequently amended. This has been substituted by adding a few words, my lord. Page 26.
In respect of in the colleges.
Yes.
In the
colleges established prior to 2nd June 2014. These are the words added, my lord, after the clause.
Yes. All right. This the challenge.
Yes.
We got it. Now.
But effectively, now the sum and substance of this
100%.
Yes.
In respect of educational institutions established after formation of the state of Telangana.
Yes.
In educational institutions set up after 2/6/2014, 100% local and candidate. Nobody else can get admission.
Yes.
Right?
Yes.
This is the effect. This is it, Mr. On facts, Mr. Rao.
Yes.
Now we go to your submissions. We can now proceed faster.
Yes.
Because you argued to some extent Pradeep Jain and all that.
Yes.
Let's.
Lord, I'll not go into the judgments, my lord. I've already.
You will have
out the relevant paragraphs.
Yes. That is what is important.
Yes,
right?
I've called out the relevant
because your tendency is to pass on the judgment without telling paragraphs. So
yes, the relevant paragraphs are
we have made it very clear that those councils who don't refer to paragraph, we will also not refer to judgment. Yes.
My lord, 100% reservation, my lord, has been held. Yes, 100% reservation has been held to be wrong, my lord, violate unconstitutional and violate of Article 14.
Which judgment?
Yes, Pradeep Jain is the first one.
Which para? You have not written here again, telling that I have written nothing.
My lord, paragraph 20.
Mr. C first submission.
The judgment portion, my lord.
All like 8 judgments thrown on our head without referring to paragraph.
I have called out the judgment, my lord.
No, Mr. We are telling you again, Mr. Rao, that we will refer only one judgment with the judgment of which you refer to paragraph.
But I have called out the judgment itself. Page 5, my lord.
So you tell us,
After the synopsis.
Pradeep Jain is para 20.
20.
Read para 20.
Your lordships, my lord.
What was Pradeep?
We agree wholly with these observations.
Pradeep? Where is the compilation of judgments?
Compilation.
Give. What is Pradeep Jain? What is Pradeep Jain, Mr. Rao? We know what, but you have to refer back 2 sentences, or you want us to read and find out.
20, my lord.
What was the controversy arose before Supreme Court?
Yes, yes. But several matters, my lord, were carried, my lord, in the context of, my lord, domicile.
What was the provision?
My lord, several states had different provisions. So uniformity, my lord, there was no uniformity. In that context, my lord, these matters came up for consideration, my lord. In the context of domicile, my lord, the first paragraph, my lord, the question is whether consistently with the.
That's what we were asking. Yes, we have read it.
The context of domicile.
The issue before Supreme Court was whether reservation can be prescribed on the basis for admission to medical colleges based on domicile, with the irrespective of merit. This was the question.
Yes.
That everything has to be read in context, Mr. Rao. You will appreciate para 20 then.
Yes.
Yes, go ahead.
Yes, yes. The only question which remains to be considered is as to what should be the extent of reservation based on residence, requirement, and institutional preference. There can be no doubt that such reservation cannot completely exclude admission of students from other universities and states on the basis of merit judged in open competition. So-and-so rightly remarked in so-and-so Jagdish Saran case, reservation must be kept in check by the demands of competence. You cannot extend the shelter of reservation where minimum qualifications are absent. Similarly, all the best talent cannot be completely excluded by wholesale reservation. So a certain percentage which may be available must be kept open for meritorious performance regardless of university, state and the like. Complete exclusion of the rest of the country for the sake of a province, wholesale banishment of proven ability to open up. Hopefully, some Dalit talent, total sacrifice of excellence at the altar of equalization. When the Constitution mandates for everyone equality before and equal protection of the law, may be fatal, folly, self-defeating educational technology and anti-national if made a routine rule of state policy. A fair preference, a reasonable reservation, a just adjustment of the prior needs and real potential of the weak with the partial recognition of the presence of competent merit, such is the dynamics of social justice which animates the 3 egalitarian articles of the Constitution. We agree wholly with these observations made by the learned judge, and we unreservedly condemn wholesale reservation made by some of the state governments on the basis of domicile or residence requirement within the state or on the basis of institutional preference for students who have passed the qualifying examination held by the university or the state.
All right.
Yeah.
Next. Jagdish Saran.
I'll not go into Jagdish Saran has already been referred to in the Pradeep Jain's case. Lord Speaker, can kindly take Satyajit Kumar's case.
So you are referring to only Pradeep Jain and the other cases this?
Yes.
Other cases Satyajit
For the purpose of 100% reservation.
2 cases.
Yes.
We will record that you are only relying on these 2, right?
For the purpose of 100%.
This even 1 is enough. Mr. 1 is also enough. 141. Yes. Satyajit Kumar. Yes. Yes, Mr. Rao.
Yes. But here, Satyajit Kumar's case, my lord, that
Where
scheduled,
is the citation?
my lord, 2022. SEC online, SC 954, my lord. Paragraph 98, 99, my lord.
98.
But this is a wrong
This
citation. Yes, this is
Ah.
live law. But
This is
live
no.
law, I'll just give the paragraph.
Arey, Mister, don't refer from SCC and give us a copy of live law
No,
citation.
I'm sorry. I'll give the.
We are this must be reported in SCC online.
Yes, SEC it's reported.
Then why are you giving us live law? The paragraphs won't match.
Well, paragraph 24 in this citation. Paragraph 24.
Para?
24.
What citation?
Well, may Satyajit Kumar. Live law site.
No, this live law.
Live law. May I read from 23 onwards? Just 2 paragraphs. At this stage, it is required to be noted that even the impugned order notification dated so and so, and the advertisement providing 100% reservations for local residents of concerned scheduled areas, districts, can be said to be violative of Article 13 of Constitution of India. As observed here and above, the impugned order notification making 100% reservation for the local resident of the.
This was in connection with an employment.
Yes,
So Supreme Court said teachers that article violative of Article 16(2).
Yes.
Correct.
Prescription was
100% local candidates. They said that the Supreme Court said that it violates the mandate under Article 16. Correct.
And slightly to an extent, my lord, where.
No, bang on is Pradeep Jain.
Yes, yes.
Bang on to facts of your case
Yes,
is Pradeep Jain. Next submission. Now next, Mr.
Yes, next submission. Lord, the next submission.
We have already noted it down.
Yes. The state is incompetent, my lord, to legislate, my lord, in these affairs, when they are governed by the presidential order and
No.
the reorganization, my lord.
Mr. You just now you have read it under section 3 and 15. State is competent to enact the
3
amendment, enact the rules.
Capitation Fee Act. 3 is a state legislation. 3 is a state enactment.
This is state enactment.
No, I'll just take your lordship there. Lord, state, my lord, my submission is state is incompetent to legislate or prescribe, restrict. My lord, I meant.
This should be the first ground then. You are saying 100% thereby you thought that you have conceded the power to amend the rules.
No, my lord.
No. Yes, Mr. You have to hurry.
Yes, yes.
It's not that leisurely for 5 days you will argue.
No, my lord.
You have to hurry. We have already noted down these submissions. Hurry. Basically, they have to this thing.
Yes. My lord, the amendment is carried out, my lord, in exercise of power under the state enactment, that's the Capitation Fee Act, my lord.
Amendment under section 15 and 3 and 15 of the Act.
Yes. But the effect of the amendment, the effect of the amendment, is in violation of the presidential order, which is in force. And also contrary to section 95 of the Reorganization Act.
No, effect of amendment is like violation of presidential order and section 95. Therefore, it is liable to be quashed.
Yes.
You cannot say that they don't have power under 3 and 15. Power to
saying it.
Power to enact, power includes power to amend also.
Yes.
So therefore,
power under the Capitation Fee Act is a state enactment, which does not
no,
prescribe.
state of Telangana is not making rule for Himachal Pradesh. Right?
The prescription
of Karnataka. They are making only for Karnataka. So state act, state legislature enacting for Telangana. Right? They are not. What are you, I mean, contending?
The domicile prescriptions are laid down in the presidential order.
Sir, please understand that the impugned amendment violates fundamental rights under Article 14.
Exactly,
1 minute. Article 14 and 16 of the Constitution of India, or is violative of presidential order, or is violative of Section 95 of AP Reorganization Act, does not denude the authority from enacting an amendment. What are you?
Well, except for
No, we have got it right. Your submission is there. It's contrary to, therefore they have no power to enact, amend.
Except for the presidential order.
1 minute.
May I just
1 minute. We have understood what can be done. You are arguing that
may I just,
amendment
may I
is
just
in violation of.
clarify
This is what amendment is in violation of Article 14, 15, 16, and.
May I just
1 minute. We are writing down, Mr. All the seriousness.
I'll just clarify and then Lordship.
Presidential order and 1974 and Section 95 of AP Reorganization Act. Reorganization Act. Therefore, no power to amend the rules. Right.
But except for the presidential order, the state cannot.
No, the correct, like we have noted down your proposition that the effect of impugned amendment is violation of Article 14, 15, 16 and presidential order and Section 95 of the Reorganization Act. Therefore, state has no power to amend the rule. Right? Okay. Next.
Just to elaborate, Millard, on that submission, Millard, except for the presidential order, the state could not have had any power to impose any restriction in terms of Millard, place of birth or residence. That is the submission, Millard, except for the presidential order. Because of the presidential order, Millard, but except for the presidential order, the state has no power to Millard, place it.
So they have under presidential power order, they have the power. Yes. Except for presidential order, state has no power to.
The state derives.
Has no power to do what?
To place a restriction on by reason of place of birth or residence.
To place a restriction for.
By reason.
A restriction.
A person by reason on any person.
In the matter of admission, not restriction. They are not saying that those who are not born here, they can't stay in Telangana, not saying. It's only admission to education, MBBS course.
But in
you have to be precise, Mr. Rao.
In other matters
of admission to
born here, yes, I'm sorry.
Matter of has no power to play on the admission on the basis of residence, right?
Yes. Place of birth and residence.
Correct. Now.
Yes.
Correct. Therefore it has no power.
Yes.
So this is your first submission. No power to enact the rules. Then alternatively submission is if we hold that it has power to enact the rules, then you say 100% reservation not permissible. Pradeep Jain and Satyajit Kumar. And third submission. Quick, Mr.
Just to elaborate on this, this is the most.
Yes, how you have elaborated now. We have noted down. But type it, Mr. This week you cannot make us write everything.
No, I've already given. This is a substance of my submission, citizen is governed by rights given under Chapter 3, the fundamental rights. 14, 15, your lordships. 14, 15, 16. Those rights,
we did not know.
My lord.
We did not know till you told us.
My lord, your lordships, yes.
We did not know till you told us that citizens are governed by Article 1420. We did not know really, Mr. Rao. Yes, go ahead. Yes. Yes, yes. What elaboration?
The restrictions put by the state, my lord. The state has no power to put any restriction, my lord, in terms
We have noted it down.
Your lordships may kindly see Article 13 of the Constitution, my lord.
Yes, Article 30. Read, Mr.
Yes,
I mean, we don't have a whole day at our end. This law, you will be losing.
Yes, laws inconsistent with the
We are right of turn, Mr. We are making an effort out of turn and putting in an effort. You have to cooperate. Cannot like looking at the constitution. The court is asking.
All laws in force of the territory.
You have to give us reasonable time to do this thing also. And the Supreme Court says that we can deliver judgment in 30 days. Right? You cannot go there and say that it should be delivered in next 24 hours. Be reasonable, right? There is nothing, right? You have argued it at length also, but please proceed fast. That's what we are saying. We have given you enough time on facts to understand what rule, all that. These are legal propositions. It is not that, Mr. You are arguing for the first time in the history of ever since the Constitution has been enacted, right?
Article 13(2), the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention be void. Article 13(2).
So, rule is in contravention of Article 13(2) and void.
Yes. My lord, may kindly see Article 35, my lord. Legislation to give effect to the provisions of this part, notwithstanding anything in this constitution, Parliament shall have, and the legislature of a state shall not have, to make laws with respect to any of the matters which under clause 3 of Article 16. This is relevant. Clause 3 of Article 32, Article 33, and Article 34 may be provided for by law made by Parliament. May I read again, my lord? Parliament shall have, and the legislature of a state shall not have power to make rules with respect to any of the matters. Kindly
yes.
Article 16(3), my lord. Yes. Article 16(3).
16(3) admission to educational institution.
Yes.
Right?
Yes. Any requirement as to residence. Nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government of or any local or other authority within a state or union territory. Any requirement as to residence within that state or union territory to such employment or appointment. But Article 35, but only the Parliament has the power. Yes.
This is in required to public employment. This is Article 16(3).
16(3).
Parliament in relation to public employment. This is not public employment. This is admission to an educational institution.
Stressing on the words any requirement as to residence within the state. Only these words. Article 13 read with.
Again reads Article 63. Notwithstanding. Nothing
in this.
Nothing in this article.
Nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or class of employment or appointment to an office under the government of or any local or other authority within a state or union territory, any requirement as to residence within that state or union territory prior to such employment or appointment.
This is employment and appointment to an office.
Yes.
So according to you, in view of, we have got it, in view of Article 16(3), the state legislature has no power to enact the law, to amend the law.
Yes.
Huh?
Yes.
Next, where have you written in your synopsis? All this is.
Well, the second
in view of
Article 13 and It's violative of Article 13, read with Article 35.
Article 16(3), state has no power to amend rules. Correct. Then next. Yes, please. Next.
Yes. The next submission, my lord, the GO is in violation of presidential order.
That you have done.
That's the Andhra Pradesh Educational Institutions Regulation of Admissions Order, 1974.
The third point.
Yes, please.
To then say third submission. Third submission is violation, amendment in violation of GO. What is it?
Yes. My lord, for this, may I just take a lot? The total judgment, my lord. 21268, my lord. 21268.
So you want to say that presidential order reserves 85% for local candidates and 15% for unreserved candidates, and this GO violative of presidential order in as much as is reserved 100%. Correct. No difficulty. Then next.
And only to a small extent, my lord. Your lordship sees your lordship judgment, my lord.
We have understood, right? It's in violation of, we told you, right? What are you arguing? Then next. Next is what?
Lordship's judgment, my lord. Paragraph 37, 21268, my lord, for a moment.
Hey, Mr. This is violative of presidential order.
Yes.
This is the submission.
As a matter of fact, my lord. As a matter of fact, your lordship, my lord, recorded all the submissions made by the University Council, my lord.
That we will hear. So that is another submission that in some other case he argued. What he argued?
My lord, state and university, my lord.
They argued that the presidential order is the basis of enacting 2017 rules. Correct. Para 37.
Para 37 and 40.
Yes, 21268.
Presidential order is intact. It applies to medical admissions, and that
presidential order applies to medical admission and is basis for framing 2017 rules, right?
Yes.
Correct. Next, Mr.
My lord. My lord, the
next submission.
Yes, next submission.
Amendment in GOR 371D and 95.
Repugnant, yes, my lord. Repugnant to 361D and section 95.
Yes.
So already covered through the second and third submission, my lord, that in the face of the presidential order, they cannot be an order.
No. What is like how it is repugnant to one? You elaborate 371D.
The fact that the university admits that the presidential order is the basis for enacting rules 2017. In the face of the presidential order, there cannot be a amendment in derogation of that presidential order.
Therefore, contrary to Article 371D.
Yes.
And what is Section 95? How?
Section 95 is the continuation for 10 years. 10 years.
Quota for 10 years.
Yeah.
All right.
Existing quota for
that
10
we have
years.
seen in that previous.
That's a central enactment, my lord. Yes. On both these, my lord, they can only be, my lord, in consonance of the prescriptions. They cannot be in derogation.
Next submission is what rules of the game cannot be changed midway.
Yes, my lord. For that purpose, my lord, kindly see the date.
How it is changed midway?
Dates, your lordship, may kindly see, my lord, the next page. Dates I have given 6-3.
Hey, what is this? This Article 254 and all this? You have written on third page.
Well, that is how, my lord, Article 254, my lord, provides that any law which is made by the state, kindly see Article 254, my lord.
To the extent of if there is an enactment by the central government on the same subject matter, if the state enacts a law and there are inconsistent provision, the the law made by the state legislature to the extent of inconsistency shall be void.
Therefore, the
Which is
presidential
the
order,
law.
yes.
So
The presidential order already prescribed eligibility criteria to all the candidates.
all right, got it. So it is in view of presidential order, rules are void under Article 254.
Yes.
Fine. Amendment to the rules.
Yes.
Yes, correct. Next.
My lord, kindly see the dates, my lord. Just to
Now
impress, my
next
lord,
is
how
five.
the rule was changed after the session commenced, my lord, 6-3, my lord, March. The next page, my lord.
Session?
The academic session.
No.
The NEET academic session commenced on 6th March, my lord. I made an
Notified the
application.
examination.
Yes, notified it. I made an application. But then I wrote an exam and results were declared on 13-3. This is the
After declaration of result, this rule was amended.
3-7.
After declaration of result of NEET on 13-6, rule amended.
Yes.
Therefore, rules of the game have been changed.
Cannot.
Rules of the game have been changed, which is not permissible.
Yes. Quotas.
Yes. Mister, what else? Oh, you have heard the other bunch also. Same argument in NCC candidate also made. Rules of the game. Good. Good.
Yes. Here, my lord, I had that lord, advantage, my lord.
No, that we are complimenting you, mister, for being aware and alive to this situation.
Yes.
We are complimenting you. Yes, next.
Lord, this is a public notice of the examination. I'll just take your
Nobody is disputing.
No, I'll just take your lordship to next. This is the next page. Just
Examination was held on, Mister, the examination was held on 7th May. Result has been declared on 13-6.
the next page.
We are sure that Advocate General cannot dispute this fact that after declaration of result on 3rd of July, rule have been amended. He will not dispute it. So there is no need to give document.
The next page. This is a press release, my lord, issued by the National Testing Agency. It has the, I'll just browse through with the pages, my lord. Just browse through the page. I'll not take your lordship, my lord, to the details of the.
No. National Testing Agency issues a press release that is binding on us under Article 226.
On the matter of facts, my lord, where results were declared and certain aspects were.
Council, we have appreciated and understood that this thing, the rules of the game have been changed, which is not permissible. We have appreciated what National Testing Agency says doesn't bind us under Article 227. It is not a law laid down under Article 141. We have no hesitation in saying if you are trying to contend that.
I did not, my lord. I was trying to impress that applications were received, candidates enrolled and had all the statistics available, my lord, to all the authorities. That's how, my lord, meritorious and other benchmarks were available with the authorities. That's how I was trying to impress, my lord.
No, it after all it boils down to this only.
Yes.
That it has been changed. He is not disputing. Still, you want to argue.
And the other, my lord,
That's it.
yes,
5 submissions.
The other point, right? Legitimate expectation, my lord. Section 95, we had 10 years, my lord. 10 years.
It's not mentioned here.
Yeah, the last one. Last bit.
Yes. Legitimate expectation what?
Yes.
Oh, you have
Section
only
90
written only legitimate expectation.
This also carried
Yeah,
forward, my lord.
what?
That one. That section, yes.
Yeah,
Section 95, my lord. It had a, my lord, period of 10 years governing the medical admissions, existing quota. All the candidates, my lord, were prepared for a situation.
Oh, you have this thing improvised on the submission made. We must compliment you by saying that you have improvised on the submission with regard to legitimate expectation. He didn't argue this. That it's a 10 years, right? Correct.
They were made to believe that the existing alert would be available for the next 10 years. And 1 year is remaining, my lord. These candidates, my lord, are deprived, my lord. And while, my lord, the matter was being admitted at the first instance, my lord, the Honorable my lord, Court, at the first instance, my lord, when the matter was filed and came up for the first instance, the Honorable Court, my lord, recorded that it was prima facie in violation of the presidential order. The order, my lord, at 12-7, my lord, 12-7, same matter, this batch matters.
No, that's an interim order. It
Yes,
doesn't
yes,
bind us.
yes.
It is not a precedent and doesn't bind us. It is being heard finally. What is it?
Prima facie, prima facie.
No. When you argue a civil suit finally, you will say that in order of injunction, court said no. Order of injunction court said that prima facie case is made out, so I will rely on
Not
that.
for your lordships, my lord, offer of the candidate, because your lordships have been taking a my lord, view that these candidates approached lately. These matters were being heard. There was a prima facie view from the Honorable Court that it is
No. What candidates?
The candidates who approached, my lord, late or
No. We are in your case. We have not said that you are approaching late. You don't argue somebody else's case which is not before us.
yes. But there are fresh matters, not those matters, my lord. There are fresh matters now pending before your lordships. They'll come up now. In those matters, my lord.
Which case?
The matters filed yesterday, my lord. They'll come up today, your lordship, my lord.
Three cases.
3 cases.
We have agreed to decide all of them on merit. We don't understand, Mr. What sort of questions did we tell you that these petitions are barred by limitation or by delay?
Just an apprehension, Lord.
Let Advocate General argue. We have noted down your submission. Have patience. I mean, let him argue first, then. So legitimate expectation violated, correct?
Yes.
Yes, Mr.
With your lordship's
No. We hope that you have heard him and we have heard him separately. Don't this thing make additional submissions, whatever you want to.
All that I wanted to make submission is your lordship's.
Which cases you are appealing? 1 minute. Which case you are appealing?
Item 13, 15, 17, 21, 22. In fact, your lordships, I have made a list of my cases that will be handed over to your lordships.
No. Tell us.
22, 23, 24, 25.
So you could have said 22 to 25, right? All right. Go ahead. 25.
Till 46, your lordships. 46. Till 46. And 52. 69. 70, 71, 76.
70.
71.
76. What is the additional point apart from 5 points?
Your lordships, if I may be permitted to hand over your lordships, I am only referring to a Supreme Court judgment, citation 2021.
So you are adopting his submissions on 5 propositions?
Yes, your lordships, and I am handing over the brief. I am handing over the brief submissions, your lordships, which I have consolidated the points.
What is it? What brief submission? Nobody is consolidated. Nobody is giving us.
And the proposition note also, your lordships, we have given over along with the compilation of that.
This all has been argued, right? It is violative of Article 371B.
Certainly, your lordships.
Any point 371B and this thing 371B article and Section 95 Reorganization Act violative and this Supreme Court judgment Indira Sahni. Correct. Thank you, Mr.
Your lordships, before Indira Sahani, your lordships, there is another judgment that I am relying upon. Chibrolu Leela Prasad Rao and others versus State of Andhra Pradesh and others.
Para 168. 168.
I am relying upon it for 3 propositions, Your Lordships, in my proposition note.
Mr.
Yes, Your Lordships. 168. I am relying upon 168 on page 125 of the compilation, Your Lordships. This case, Your Lordships, the dispute therein was 100%. In fact, I'll just draw Your Lordship's attention to page 30, Your Lordships.
100% reservation is bad. You are adding new case law. Pradeep Jain and here cited some other judgment, and this is the third one. The state of
Yes, Your Lordships.
Rao
125.
Rao versus State of Andhra Pradesh 2021 11 SSC 165.
Page 125, last paragraph, Your Lordships, penultimate line. While dealing with the government order wherein 100% reservation was granted to the scheduled tribes in the scheduled areas, we direct the respondent states not to exceed the limits of reservation in future order.
No, Mr. What you are required to tell us, this is a case dealt with admission to educational institution, employment, providing reservation in local body. What is it?
This is with respect to employment, Your Lordships. However, the question of 100% reservation was dealt with.
That's correct. So that we understand. But you should tell us that this was dealing with employment 100%, and Supreme Court said that violative of Article 16. Correct.
Yes, Your Lordship.
168. Next.
Further, Your Lordships.
Satyajit Kumar, he has already relied. He has already.
Paras 92 and 93 of the same judgment, Your Lordships.
What same judgment?
The very Chebrolu.
Satyajit Kumar.
No, Your Lordships. Second proposition. This one, I am again relying upon the same judgment. Paras 92 and 93.
So 3, the Supreme Court has passed strictures against state of Telangana and Andhra Pradesh for making 100% reservation. Beyond 100% reservation is para 168. Then 100% reservation is violative of Article 14 and 16 is para 92 and 93. And third is context of reservation cannot be contrary to presidential order. For that, para 145.
Obliged,
Yes. See, you have prepared the note so well. Yes, that's what it is meant for. Convey what you want to say. Next.
Rest of the submissions, Your Lordships,
You adopt.
I adopt.
Thank you. Others, Mr. You are appearing for which PT, the serial number?
I am appealing for 183264.
1 minute.
183264.
64.
Yes, 183264.
You are adopting?
I'm making independent submissions, Miller.
No. So you are not adopting these.
Yes, sir.
You are not challenging on the ground Pradeep Jain, etc.
Yes. I'm relying on these two judgments.
No. While adopting, you are making additional submission, or you don't rely on them?
Yes, Miller.
No. Hey, Mr. We will have to write. That's why we are asking you. All right. Don't want to rely on that. Fine. But Mr. These people have argued well. These both Mr. Rao and the counsel who appeared through video conferencing.
Entire crux of the issue boils down to situation before 2014, situation after 2014 regard to the medical admissions.
What have you given?
I have given two judgments.
Our responses are like through the bench clerks are slow. They don't You have already given, but they are looking at us.
Yes.
Yes.
Sir, entire crux of the issue is on to say education admission, mode of admissions before 2014, mode of admission after 2014. Before 2014 situation is Virat. In view of Presidential Order 371D.
No. First of all, you tell us whether you are adopting their submission. Adopting. And in addition, you are making this submission. That's what we asked. You said I want to make independent.
Sir, no problem.
What admission prior to
2014? Process admission process prior to 2014 and after 2014. That is bifurcation.
Before 2014, in view of the 371D and presidential order, a combined state was divided into three areas.
Local areas.
Telangana, Rayalaseema, Coastal. So
Three local areas.
three local areas. Three local areas.
No, what is that?
In state education institutions also divided into two categories, my lord. Statewide institutions, non-statewide institutions. I will not take more than 10 minutes.
In your interest, Mr. We can continue to hear it for 1 week, no problem. Yes, sir. No, the purpose of making hurry is Mr. Rao, not to Mr. Rao. The purpose of hurrying up is to decide it on faster basis, not that it's a pleasure to hear you and we can continue next 7 days till you are tired. Until you say that no, I cannot speak any further. 5 hours a day, if you argue, you will soon realize. But we have heard you, you have conveyed everything. Yes.
So, the education institutions also divided into two categories, statewide institutions.
That's correct.
Non-statewide. The question is only non-statewide universities and local universities, local educational institutions. In local education institutions, by virtue of the presidential order, 85% of seats reserved to the local candidates.
Non-statewide
institutions. 85% of the seats reserved to the local candidates. 15% remain open to the.
That is now amended, no 100%. That's why you are here.
This is the situation before 2014. Sir, after this amendment, the question is after amended seats increased after amendment or institutions established after amendment comes down to the reorganization. By virtue of the reorganization act, same situation protected up to 10 years. It is expired in May 2024. So my submission is that this GO is violative of the section 95 of the.
That they have already argued. You have adopted.
But the answer, the question is decided by the Honorable Court in the earlier judgment. It's a lordship I given. The 2016 SCC online, Hyderabad 624.
Which paragraph?
The relevant paragraphs, may see.
Relevant has number
19 Millard. Paragraph from 19 onwards it starts. Lordship may recall all in 1989 I brought to your Lordship notes this judgment also. 19, may I read it?
Yes.
It's true that Article 371D as existed prior to 2/6/2014, there was a reference only to the state of Andhra Pradesh. But Andhra Pradesh Reorganization Act 2014, the words state of Andhra Pradesh were substituted by the words state of Andhra Pradesh or the state of Telangana. Therefore, the contention of the learned advocate general, additional advocate general is that after the bifurcation of the state, entire presidential order will have to be applied independently to each of the states. That there is no question of applying provisions of the presidential order to combined state, as if both states existed together even as of the date. Theoretically, the learned advocate general may be right in saying that after two states are formed, the provisions of the 371D may have to be applied independently to each of the states. But unfortunately, the second respondent university, the key to the problem is to found in section 95 of the Andhra Pradesh Reorganization.
You don't know. My additional private secretary, you don't know. The other person who is there, come here. She says she doesn't know PLN. Huh? Who is PLN? Huh? Who is he? Who was not well and has come today? Who comes with me in the court? He doesn't know. You are not employed in High Court.
context of the judgment, my lord, there's a MCH oncology seats.
No, we have read it, Mr. If you don't tell, what do you think? We don't read. We have read it. 3 seats were reserved for local candidates for admission to PG course. That was under challenge. In that context, it is being said.
Yes, ma'am.
That's finished, Mr. 130.
The only point is in section 95 of the Reorganization Act.
They have already argued.
Yes, section, my point, section 95 of the Reorganization Act, Lordship is the same judgment para 19, it was extracted.
No, section para 19, it is not extracted.
Para 20 blood.
Yes.
Equal opportunities for quality higher education of all students. In order to ensure equal opportunities for quality higher education to all students in the success of states, the existing admission quotas in all government and private. So, Lordship, is the admission quotas, not seats, my lord. Admission quotas means existing before bifurcation of the state, after bifurcation of the state. It will apply to the before bifurcation of the state, after bifurcation of the state. Same quotas has to be continued. So that is the interpretation given by this judgment, my lord. The next paras, may I read it all? Next 21 para. It's clearly.
You give us paragraphs number, we will have to read it. In any case, we can't decide the case without reading.
Yes,
para 21, then
31 will. 31 is the final 31.
The above timetable, above table.
Below the table, sir. Below the table.
It can be seen. No, you read the table first. Then only we will understand what is below table.
The table is regarding the fractions of the seats, my lord. 1 or 2 takes. Yes,
read,
1 or 2.
Read para 29. What?
Yes, madam.
A table, we must know what is the table, don't only below table.
Yes. Yes. Interestingly, after having held so, full bench of this court also provided tabular column with respect to the application of the existing quota to various students. When the number of seats available in the course varied from the 1 to 20, the table provided the full bench of this court in B. Sudhakar in paragraph 25 of the judgment may be usefully extracted as follows. This is applicable to only if there are 1 seat or 2 seats existing, how to allot the seats between the local and non-local. Next para 31 Miller. The relevant para is 31.
Read, Mr. Don't look at us. It is not, we are not seeking admission to NEET UG course.
The above table squarely answers the contentions of the learned Additional Advocate General. In other words, what was available to the local candidates in the state of Telangana MCH before the bifurcation was only 1 seat, which is now available to 2 seats. Since they have created 2 additional seats, the number of seats has gone to up to 3. The provision up to the subparagraph 2 of the paragraph 5 automatically comes into play. The effect of which is not nullified by the section 95 of the Andhra Pradesh Reorganization Act 2014, but reserved by section 95. In view of the above, petition is allowed directing the respondents to treat 1 of 3 seats as unreserved seat available to the most of the meritorious candidates fill of the said seat which most meritorious candidates. So the entire issue of 1 seat existing before the bifurcation, 2 seats created after bifurcation, 3 seats has to be considered. That is the see, what an argument put forward by them now the state. Same argument was made before this.
No, according to you, all seats should be considered for non-locals, right?
No,
all 3 seats have to be considered. This is what you are arguing. There were 3 seats. All seats to be considered mean all seats for non-local candidates to be considered.
Only 1 seat.
And local should go to which state then?
I am not saying 15% to the extent.
Locals will go where everything is to be given to you, then they go where?
Only to the extent of 15%. That is my submission. The next judgment same
that we do not decide what is the extent of reservation. We don't. That we will examine the validity of the rule only.
Extent of reservations is 15% only. There is no dispute at all below as far as non-local systems. That's what the presidential order. Only 85% seats local, 15% non-local. See, next judgment is.
You are saying 15% for non-local should be reserved.
Yes, non-local 15% non-local.
No, that will automatically, once supposing if it is struck down, the old provision revives. That provides for 15%. There is no question of arguing. Yes.
The next judgment also same similar aspect, my lord, held by the Honorable High Court judgment, basing on this earlier judgment, my lord. The context is similar judgment, my lord. Basing on the same judgment, I have taken the view of the same judge, judgment.
This is in service local candidate.
In service local candidate admissions into PG courses. That's
Which paragraph is? We will not cite this judgment if you leave like this without leaving the paragraph.
the earlier occasion, if I go, sir.
Which paragraph?
18th paragraph. From 18th paragraph.
Para 18.
Although reference is made to Article 371D of the Constitution of India, however, the main focus of the petitioner's arguments revolves around the benefit accruing to them under Section 95 of the 2014 Act. Therefore, the present order will focus around this four issue. Section 95 of the 2014 Act, which has already been extracted in the preceding paragraph, categorically provides that Government of Andhra Pradesh and
So therefore, with reference to this, you want to say that the amendment is violative of Section 95.
Yes, ma'am. 95.
Is that you have raised a single, they have argued already. Mr. Rao and other counsel have argued already. Thank you. Anything else? Anybody else, madam? You are appearing in which case?
Item 56. Item 16.
16.
16.
You adopt this.
I adopt only a very short submission I will be making, Millard. The aspect, Millard, that these students of AP and Telangana.
To argue, then we will hear you after the break.
Item 56, Millard. Item 56.
63 and adopting. Item, which other case? Item?
56 is also adopting.
56.
Yes.
And you 16 we will hear, madam. Madam, 16 we will hear you after the break.
Millard,
How much time will you take?
Only 2 minutes, Millard. Only one factual submission, Millard, I want to make is that they are not eligible, Millard, for other states. They are only eligible to compete among these two states.
That doesn't decide we are testing the validity of the rules, madam. That can't be struck down on the ground that they are not eligible for other state.
I mean, the other aspect, Millard, is that all
these, they have argued elaborately, madam. We have heard them.
Yes.
Anything else if you want to add, please add.
My lord,
You are adopting the submission.
Adopting, Millard.
Yes.
My lord, item 47, 58 and 62, my lord, we are adopting the argument.
1 minute. 47,
58 and 62, my lord.
47, 58,
62, my lord.
adopting submissions. 61 also, right.
Millard, item 20, 31 and 57, Millard.
20,
31 and 57.
you are adopting all. 53 also. PLN. Who is PLN? PF. No. His name is PLN, right? PL. Maybe I call him PL. These three are being heard, right? 1 to 3 are being heard with this bunch. So you call item 4. Your 3 petitions are being taken up with the bunch, right? So they will not be called. We proceed with item 4. 4, Mr. Madam.
Item number 4. Please
Yes, Mr.
Already a local candidate, my lord. A local candidate certificate is also already given to me by the relevant authorities, my lord. That's at page number 31, my lord. I squarely fall under the clause, rule 3, clause B, my lord. I passed my intermediate in the year 2019 and I had been residing in Kodat, my residence, since the last 4 years. I also submitted representation, my lord. Along with the relevant documents.
See this order and then argue, madam. This all we have dismissed these petitions on the ground that delay and latches.
Lord, the delay is not wanton, my lord. I have also already submitted a representation, my lord, at page number 32, my lord. He's only a student, my lord. And I cover under the.
If you want a decision on representation, it's fine. If you want an order on merits claiming the benefit of our judgment, this is the order which we are passing.
Lord, my only submission,
claiming the benefit on merits, right?
I would better go with the consider representation order than this. Lord, but the only difference that I have in my favor is that, my lord, the local candidate certificate is already issued in my. I accept on my.
How your Tehsildar gives local candidate, we cannot say from sitting from here because of restrictions of the place. It's a matter of common knowledge. All right, madam, then it is dismissed, right? Give that order, madam.
Lordship may consider my case.
Then why are you arguing? You should have said that representation we are passing order in every case. Otherwise, direction, there are only 2 options. Direction to consider or this dismissal. Choice is yours.
I was just trying to persuade your lordship, my lord. I agree with whatever your lordships to say.
Madam, we cannot take a different view because you are appearing.
Yes,
our orders are binding on us.
I understand.
That even if lawyers may not tell us, but we are cautious. So keep it here.
Yes.
So that 2 inconsistent orders are passed.
Yes.
Where is the order of deciding represent? You have annexed it despite that taking chance, right? Not fair, madam. Not fair. You are a young person and lot of time to spend in this profession. Therefore, we are telling you, this is not a fair approach to try and get an order and then say that representation. You are just trying to know the mind of the court. If it grants the relief, fine.
I was
not fair.
I'll change it. I'll take your lordship's suggestions.
Madam, this order at page 39 disposed of. Certified copy today.
I'm deeply obliged.
No, better improve, madam, and be fair. This thing we are telling all the young lawyers, you are officers of the court and you owe a duty to be fair to the court at all times. Cases will come and go. This is not the last case of your career.
I understand.
You will appear in next case. We will remember this that, oh, she is a counsel who tries to know the mind of the court.
No.
And then alters her submission.
I will not repeat it. Thank you.
Yes. 5. What is which page, Mr.
B category, my lord, and page number 21 is the order, yeah, lord.
21.
Yes, my lord.
Certified copy, both the cases, no, with consent of parties heard finally and certified copy today. Hmm. Yes, Mr.
It's 30 lordships.
Page
30,
30. Yes, 30. Hmm. Item 6, page 30, madam. Hmm. Mr. Yes,
Page 25 lordships.
25.
Dispose of the representation, my lord.
8. Yes, page,
I'm appearing for the petitioner, Your Lordship.
page. This is something different, right?
Yes, PG. PG medical seats, Your Lord.
Why have you got it listed on a mention memo?
So what case?
Huh?
So old case.
Old case?
This is supposed to be listed on 28 August, Your Honor. My Lordship, it was not listed in the morning. I have moved a motion.
Why you moved it today lunch motion?
My Lordship, there is an urgency. Why? Because phase 2 counseling is likely to be commenced from second week of this month. So why? Because he is falling under the non-local category.
Tomorrow at 6:25 a.m. in the morning, there is likelihood of rain. If the counseling is scheduled, Minister, it is never concluded in a single day. Right?
Lordship.
What is this?
Earlier I have mentioned twice, but
No.
It's not listed.
Mentioned twice?
I will.
There is an order, Mr. Petition is admitted for hearing. He prays for time to file counter. Why have you not filed counter?
There was no instruction, my lord, with regard to moving of lunch motion. We could not carry the file.
No. 19.8 Mr. Prabhakar Rao had accepted and prayed for time to file counter. We are asking you.
Prospect grant to 1 week time, my lord, we'll file.
1 week you have granted on 19.8. 2 weeks have expired.
My lord, I have done Monday, my lord, we'll file.
What's your name?
My name is G. Ravi.
Learned counsel for respondent number 2 and 3 once again prays for adjournment to enable him to seek instructions.
Page 27 lordships.
Item the second number 1 second list. Page 27 is the order. Certified copy today. Yes. 2 to 6 same order.
One submission, I just want to make lordships in. Here is a case, lordship, petitioner is a PWD candidate, lordship, earlier disposed of my petition stating that she doesn't fall under PW category. Lordship, so because of that.
You are referred to a medical board and your disability.
So she could not fit the benchmark. Lordship, so she could not make an application under B and C category. Lordship, now we are asking her.
Representation, right?
Just made the representation.
Item 2 to 6.
Lordship, so they are.
No.
Item number 2, lordship, page 31 is the order.
Item number 2, page 31. Right, disposed of. Item number 3.
Page 27.
Page 27. Disposed of. Yes. 4.
22 lordships.
Page 22. 5.
24 lordships.
24. 6.
24 lordships.
24. 6 also 24. All right. 7. Extension of interim order. Where is Narasimha Rao? See, this is what it is, madam. This, he got it listed on a mention memo and not present. Show the name of the council. TVL Narasimha Rao. We will take up as soon as he comes. You tell us that he has come. Whenever he comes, you show the name.
My lords. My lords, in this batch of cases, what is voiced is that, my lord, the GO which has been issued takes away the right of my lords,
please read what is it.
my lords,
They have argued 100%.
no, my lord. The 100% which has been referred to in the class H which has been added is referable to the convener quota which is 85%. The 15% all India quota, my lords.
Note down. Note down, you will give a rejoinder.
Yes.
100 quota referable to 85%.
Exclusively for the state of Telangana in those institutions after 2nd June 2014.
15% all India quota is intact.
Is intact. Absolutely. But they can't take away, my lord. Under the NEET.
Yes.
My lords, this reserving 85% on the basis of the residence, it is, since it is in consonance with the presidential order, my lords, the voice, what is voiced by some candidates is that we will have to maintain that 15% in these institutions. My lord, nothing has been argued as to the infrastructure which has been developed by the state of Telangana after the formation of the state, my lords. The objective of section 95 or other provisions, my lords, whereas up to 10 years what is to be maintained. This 10 years is what stood as on, what existed as on the 1st June of 2014. My lord, the state, it is not their case that we have flouted with regard to those institutions which were prior to 2nd of June 2014.
No, the whole challenge is after 2/6/2014.
My lords, how
But
is
the
that?
whole challenge is that after 2/6/2014, as we have understood,
yes,
subject to the challenge is after 2/6/2014 also, you cannot provide 100% reservation in educational institution merely on the basis of residence.
Yes, my lord. Now that, my lord, the illegitimate expectation principle, in fact, virtually has no application at all. But even other way, my lord, assuming that the estimation of the students.
So next is this thing. Legitimate expectation does not apply.
Yes, my lord. My lord, after 2nd June 2014 institution, how can there be a reasonableness on the part of the students, the aspirants from those two other regions of the United States? Nothing has been exhibited excepting broadly saying that I will have to maintain this for a period of 10 years under section 95. My lords, section 95 and the carving out of the very state itself is
let us see presidential order. What does it say?
My lords.
You are saying in consonance with
my lords, presidential order, my lord, presidential order which was in fact challenged before this court that you cannot reserve 85% in the United States as then. My lord, reserving 85%. Reserving 85% by the state of Telangana exclusively for the state of Telangana region is fortified with the presidential order of 1974. The institutions which were there as on 1st June 2014, in view of section 95, I would like to continue that ratio, 15% they used to enjoy out of 85%, my lords.
No. So in other words, we can say that you are not maintaining that ratio or after 2/6/2014. And you are saying that it is permissible for you to do so. How?
My lords,
presidential order, please tell us which clause it is in consonance with.
Presidential order of 1974, which empowers the state of Andhra Pradesh as then stood was to reserve the seats on the basis of local residents.
Let's see that presidential order.
Para 5 and 6, my lords. Para 5 and 6 of the presidential order.
That's we would like to see presidential order. Get the order, madam.
Yes.
This photocopy of this order, no?
Well, they have filed it once.
No, I filed counter. In my counter, it is there.
Counter in which case?
18047.
One eight zero.
Under it. Yes. Page 17. It is at page 19, my lords, on the counter filed by the government, by the university. May I read para 5, my lords? Para 5 and 6 are of the presidential order, my lord, describes this.
Counter filed by R4. State of Telangana. Need this presidential order. Para 5.
Para 5 minutes.
The above definition of local candidate.
My lord, sir, it refers to the reservation of seats.
See, read page 10 onwards. 1, 2, 3, 4 and 5. 5 is at page 11.
My lord, say with me. My lord, I'll read para 5 of the presidential order. May I read?
The above definition.
Reservation in non-state definition.
No, para 5 at page 11 of your counter.
That is, I think, my lord, sir, the presidential order is, my lord, in page.
You said counter in WP 18047.
My lord, 18047. 18047.
Counter filed by the government, right?
Counter filed by the university is there, my lord.
So they have given government, madam.
University.
Mr. Rao, your counter is not there. Record. When did you file? We are referring to paragraph 4.
Filed on 8th August 2023. Go to the presidential order. అది చేయండి పర్లేదు.
No, Mr. AG, we can this thing, right? See, para 1 is in exercise of powers confident. Please see your this thing. Give it to them, him, madam. His file. I give Advocate General his file. He has given us. No, his file, you give it back. This is vacate petition, Mr. Rao.
Yes. Vacate stay petition.
Take it. Page.
It starts from page 16, my lord, sir. My lords, in what this is GSR 299E, your lordship was there. This is, my lords, this was issued by the central government.
President.
Yes, my lords, the Honorable President, my lords, under the article provision, Article 371D. Yes, my lord, because the state was a backward state during those days, my lords, like certain northeastern states were conferred the special status with regard to, my lords, the institutions and also the employment. My lord, this Andhra Pradesh, which was referred in the presidential order, my lords, now after bifurcation, it whether be it the Andhra Pradesh or the Telangana, it is one and the same presidential order would apply. My lords, para 5 and 6 provides for
reservation.
My lords, admission to 85% of available seats in every course provided by the Andhra University, the Nagarjuna University, the Usmania University, the Kakatiya or Sri Venkateshwara University by any educational institutions other than the statewide university or statewide educational institution which subject to the control of the state government shall be reserved in favor of the candidates in relation to the local area in respect of such university or educational institutions. My lord, para 6, the percentile of this. Para 5 deals with non-statewide universities and educational institutions, my lord. All these institutions before the lordships are non-statewide educational institutions.
Now we want to understand what is the distinction between statewide and non-statewide.
My lords, statewide institutions have been contained in the very presidential order. There are 6, my lord, your lordship, before we go to that, my lord, there are 6.
Definition is there, lordship. That page 16, Lord. Definition, not E and Lord, F.
Yes.
It's E and M.
Statewide.
Yes. Statewide educational institutions mentioned in the order, my lords, in the schedule to the order. There are certain institutions, about 9-10 institutions, my lords. Statewide university means, my lords, Andhra Pradesh Agricultural University under the Agriculture University Act, JNTU, and the Nizam Institute of Medical Sciences, my lords. The provision of reservation to the local candidate as enshrined in the presidential order, my lords, is available to both the states now after bifurcation.
What para 6 you are reading?
Para 6, my lords, yes.
Para 6 of presidential order you are referring to?
Yes, my lords, I am reading, my lords. Admission to this reservation in statewide universities and statewide educational institutions. Admission to 85% of the available seats in every course of study provided by a statewide university or a statewide educational institutions shall be reserved in favor of local candidate and allocated among the local candidates in relation to the local areas specified in paragraph 1, subparagraph 2 and subparagraph 3 of paragraph 3 in the ratio of 42%, 42 is to 36 is to 22 respectively. My lords, as regards the presidential order para 5 and 6, there is no quarrel as between the petitioners and the state, my lords. Now, the reservation as regards the 85% of for the local residences, which was earlier, my lords, is within the domain of the state of Andhra Pradesh. Now, in respect of the state of Telangana, the institutions which have been established after 2nd June 2014, the state government in its own right meets the presidential order for carving out the 100% of the local reservation, that is 85%, my lord. The convener quota is 85%, though in class H, which is added to the GO, it refers to 100% convener quota. Convener quota, my lords, if you look at the definition of the convener quota in the reading of the very GO, it is 85% of the convener quota.
1 minute, let's see.
Yes,
where is the amendment? not competent authority quota.
Yes, my lord. Convener quota competent.
Page 25. Clause H established after 2nd June, 100% of seat competent authority.
Yes, my lord. My lord, sir. Competent authority quota. Yes.
See, Mr. There are 85% is quota, 15% is all India quota. Right?
Yes, my lords.
That 15% quota remains intact. And in respect of 85% quota, with effect from in respect of educational institution from 2/6/2014, you have provided 100% reservation, 100% for local candidates.
85%.
85%, but 15% is available to the candidate petitioners even after 2/6/2014. That is.
Yes, well, sir. Yes.
15% is available all India quota.
It is made, yes, my lords.
That's what we are saying.
We'll be competing in that also, my lords.
15% all India quota.
The seat matrix has been filed, my lords.
1 minute.
Yes, correction of fact. Correction of fact. Seat matrix has been filed.
15%. What? 15% all India quota is available to petitioners.
Yes, absolutely, my lord. There can't be any dispute by them. Absolutely.
Correct. Still, correction of fact.
Advocate General is making a statement.
Yes.
If it is not correct, we will pass that order.
My lords, in fact, the university, the vice chancellor.
We understand this thing. So far as you have given impression that a student outside Telangana cannot get admission in any of the, which is not so.
My lords, in fact, the vice
Colleges after 2/6/2014, you can get admission under 15% all India quota.
That's not the case.
India quota is different from the unreserved 15% quota.
My lords, may I?
There's a distinction between all India quota.
1 minute. Rejoinder, right?
My lords, I may submit the details which have been furnished by the vice chancellor of the university. In fact, I placed this.
So, Mr. We have understood. We have understood, Mr. Advocate General, your contention is subject to what they argue is.
Yes.
That 85% seats for local candidates, 15% for all India.
Yes.
Out of that 85%, half in respect of institutions established after 2/6/2014, you have reserved 100% of 85% seats
Very well.
for local candidates. Notwithstanding that reservation, it is open for the petitioners to participate in all India quota seats, 15%, even in respect of institutions established after 2/6/2014.
Exactly.
Correct?
Yes. But that's in fact, I'll also place a fact before your lordships. There were increase of seats in the institutions which were existing prior.
Even after. Yes. This
My
is
lord.
your stand, right?
My lords, even in case of, my lords, in 20, in
And so in this thing, petitioners are entitled for consideration of their case under 15% all India quota in respect of institutions established after 2/6/2014.
Absolutely, my lords. And my lords,
What do you say? No. What do you say? This is a statement made on behalf of the government.
Correction of fact, my lord. All India quota seats are not carved out from the competent authority quota seats. They are a separate seat. There is absolutely no reservation in respect of AIQ seats. All India quota seats.
but you are entitled to compete.
They are
No, you want your share in 85% competent authority seats.
petitioners.
That is what. No. That now let us understand your case. Your case is that in respect of 85% competent category seats, there can be no 100% reservation. We are entitled to share in that also in addition to 15%.
That's
No, that's what their case.
That's not our case.
All right.
That's what
We rejoinder.
My lords. My lords, in all
How can there be, Mr. You have argued all along and still not clear. So what is your case there?
Quota,
Say don't use convener quota. We are not conversing. The language does not use convener quota. Competent authority quota.
Take a number. If there are 1,000 seats in the state,
100 seats
or 100 seats, there will be 50 for the competent or some number. A majority of the number from 100% will be reserved for the competent authority quota seats. Out of 100, 15 go to the All India pool. All India pool. That's in terms of the Supreme Court.
Yes. Hey, Mr. That is 85%. Say 100 seats, 15 seats will be for All India quota.
Yes.
In that, you sit down, right? So, no, we will permit you to rejoinder, give a rejoinder. We only want to understand this thing properly. You are not being clear or we have not been clear. So we want to understand now the scope of challenge. So out of 100 seats, 15% is for 15 seats are All India quota. All India quota seats.
There will be management quota.
One minute. Yes. All India quota seats, 15 seats along with students of All India quota. Students of Andhra Pradesh shall also be entitled to compete because they come in All India quota.
States, all of the states.
Mr. We are talking about, you are not filing the petition for Punjab and Haryana. Is it a public interest litigation? Then you are from Andhra Pradesh, right? So therefore we are giving an example trying to understand that apart from candidates of Madhya Pradesh, Punjab, Haryana, Delhi, Jammu and Kashmir, everybody, now we will take all these states, Kerala, if you are not understanding, Tamil Nadu, Karnataka, and what? Maharashtra, which states, including 25 states, more like all states plus state of Andhra Pradesh will be able to compete in 15 seats, correct?
Yes, purely on merit.
Obviously,
yes.
Nobody can give.
That is what has to be underlined. Purely on merit. 15% goes purely on merit. Competent authority quota, my lord, there are reservations. Competent authority quota.
No, don't, Mr. Don't again argue the case. Don't again, we are just trying to understand your challenge. Don't again argue purely on merit. We understand that purely on merit.
Yes.
And this is a sort of a preference given. It's not that they are not selected on merit. It's not that. That a candidate who, supposing there are 1,000 candidates in the state of Telangana, they will leave number 1 and select 1,000 candidate in the state of Telangana. Among them also, it is always on purely on merit, so to say.
In the competent authority quota.
So, Mr. Now, what is your challenge in the 85 seats?
In the competent authority.
His submission is 85 seats have been reserved exclusively for local candidates.
Yes.
Listen.
Yes.
You don't want to understand?
Sir, I'm sorry.
Please understand, Mr. Please understand that what we understand matters. If we are asking you, we will write this. An opportunity was given, he was unable to explain and did not want to listen to the court. Please listen, we are ready to hear. We just want to understand. His submission is, again, same example, 100 seats, 15 seats, don't intervene. Here, 15 seats are All India quota seats in which students of, how many states are there? 28. 27 state plus state of Andhra Pradesh plus union territories, students of union territories are entitled to participate in the state of Telangana. Right?
Yes.
85 seats, remaining 85 seats in respect of educational institutions after 2/6/2014, they have created 100% reservation for the local candidates of Telangana. Correct? This is your challenge. In respect of remaining 85%, you cannot provide reservation on the basis of domicile in view of law laid down in that Pradeep Kumar Jain and the other judgment. This is your challenge. That's it, right? Correct. That's it. What else? That's all we wanted to understand. Your challenge is that even in respect of 85%, you cannot create reservation 100%. Correct, Mr. Rao?
Yes.
100% on the basis of domicile cannot be this thing done because it is contrary to Pradeep Jain. Mr. Rao. Correct?
Yes.
This is your challenge. What is your challenge? No, challenge. We want to understand.
85%, they have to provide.
Don't confuse. If you have different case, we will de-link your case. No. Mr. Counsel, please understand. It's not that thereafter she will stand up and again we will repeat the same thing. Have you heard it? Your scope is confined to say, Mr. Rao, please speak to the counsel and ascertain from him whether challenge is same or different. Then we will de-link his case if it's different. Please request him on our behalf. Is he understood with same challenge or not? Same challenge? No. Huh?
Explain my words.
No. So you have a different case.
His understanding is different from my understanding. That is the only difference. Not actual actions.
No. But no. Mr. One thing. We must decide the writ petitions by a common order. You will say that my case was different, court has decided. We don't want to give you that opportunity.
Understanding is different. There is no difference. Let me also one minute. If she has 106.
No. Prayer your petition. Like we will with which petition, WP number. What is the prayer you have made? Please read and then argue whatever, anything. So issue is say. So 80 in respect of Mr. Rao has said that in respect of it, again we have to explain you like a child. Every student in the class will stand up separately. You were not there when we were telling Mr. Rao, correct? Mr. We are not saying for a moment that we will not hear you in rejoinder. But you must, this challenge is confined to 85 seats. You are saying that 100% reservation on domicile cannot be provided in respect of 85 seats. Correct? That's what we are saying. Then you can clarify according to your understanding out of 85 seats they should give to me, 23 they fill here, 8% they give to NCC candidate, remaining should be given to her. This all understand. But we are not deciding whether 10 should be given to him or 5 should be given to GP revenue. We are not deciding that. We are deciding the validity of Rule 32H. This is the prayer. Yes.
My lord, sir.
Now, Mr. So this is 85%. They are saying that you cannot provide 100% reservation on the basis of domicile in view of Pradeep Jain. And another judgment is this thing. Chebrulu Leela Prasad Rao. And one more judgment. Mr. Rao has relied.
My lords, the judgments which have been referred, my lords, either in relation to my lords in employment or in relation to my lords the scheduled tribe area, Chebrulu Leela Prasad has no application and the ratio laid down in other judgments.
Now you please proceed in your way.
My lords, in the matter of my lords, the opportunities that in fact gained by the state of Andhra Pradesh. I'll just, my lords, in fact, I have gave the list of my lords, the colleges which were, my lords, they will be competing, my lords, in earlier, my lords, 280 seats were there. My lords, 20 colleges, the unreserved quota was 15% at 280
Will
seats.
you give us?
My lords. 33 seats which were increased in the colleges as on 1st June 2014 is also provided to them.
What is the number of medical colleges?
Number of medical colleges as on 2nd June 2014-20. After 2nd June, my lord, total 54. 34 new institutions have come up. Total number of MBBS seats as on 1st June, my lords, 2014, 2,850. On account of the new college, my lord, 8,215.
So, how many seats have increased?
My lords, substantially more than 5,000.
1 minute.
Minus
6. $5,765.
Yes, my lord.
Correct.
Yes, my lords. Now, out of this entire, my lords, seats available.
8215 minus 8215 minus 2850. Hmm. 5365. No. Yes.
My lords, on account of this increase in the seats, total 8,215 in the new institutions and the earlier institutions, my lord, the all India quota seats are 540. In 540 seats also they will be competing, my lords. 540 plus 330.
Where do you get 330?
My lords, number of unreserved quota seats 15 in old 20 colleges earlier as on 1st June 2014 was 280. And 33 seats were increased, my lords.
So 853 seats.
Yes, my lords. Eligibility of AP students 280 old, including 33 seats increased, plus 540. They'll be competing in 853.
And Telangana students?
My lords, Telangana, by virtue of this, my lords, GO, they will be getting, my lord, 510 seats reserved. This they want to grab, my lords.
Not 510.
My lords, just my lords, if we go with 15% reservations, my lord, in 15 in these 34 colleges, that will come to 510.
No, you have reserved 85%.
85%, my lord. This table, my lords, will only indicate that by virtue of, my lords, this GO, 510 seats. Which they claim will also
we please explain this. What number of unreserved quota seats?
My lords, number of unreserved quota seats in new 34 colleges, if we compute, they are 510.
No, it should be, this quota should be, now what we want is, instead of this, another quota, another figure, that is, what will be the 8215 are the total number of seats?
My lords, this place, 900.
Yes. 8215 is total number of seats. After this thing. No.
All, my lords.
All is, no, it will be around 10,000, right? This figure will come, Mr. Prasad.
My lords.
The figure what we are trying to look at is number of seats. MBBS total, forget about Andhra, Telangana, night. It will be 2850 plus 8215.
Well, so this is inclusive of, my friend says, my lord, 2,850. 8,215 is inclusive of 2,850.
Acha. So there are total number of seats?
8,215.
Out of this, 85% you have reserved.
My lords, 8,250. My lords, I have, yes, my lords.
So what is 85% of seats? Like you have given a number for Andhra students, we want a number for Telangana. Like Out of 8215, 85% is what?
My lords, just to be
4,000?
7,000 will a fraction of about half, my lords. 7,012.
See, 80%. 6982.
69,827.
6982 seats for Telangana, and you this 15% all India quota is 853, correct?
My lords.
Huh?
Correct, my lords. Yes, my lords. 853.
So make a total of this 6,
Which is inclusive of
280.
80.
Yes, madam, please calculate it. 6982 plus 853. It should 8215 figure should come. Hmm? But this, how is this, then this figure is coming?
1233 might be the number. 1233. 15 plus 123. 1,232.
1200?
33. Not 800.
853. This is the, my lords, the calculation given by the Vice Chancellor to us, my lords.
No, we must first understand what is Mr. Total number of seats, MBBS seats, forget Andhra, Telangana, everything. 8215, or it is more than 10,000
8,450.
total. 85% of it is 6982.
15% have to go to central pool.
No.
Out of 15% have to go central pool. Remaining will not be
85%.
85%.
That's what
Each college.
No, we have got it, Mr. You are not trying. What we are trying to ascertain is how many seats are available for students of Telangana and how many seats are student for available for 15%. What would be the number of seats for this in the context, because Learned AG said it will be 853.
Yes, my lords.
No, this will be something more than 850. So you want 8215 minus 6982. 1232.
This will inquire.
You inquire
with the chief, my lord, the Vice Chancellor just now. Yes.
Advocate General, it's better for your case.
Yes.
Like 15% seats are available for all India quota seats for all the candidates of other states plus union territories, including Andhra Pradesh. Correct. 128. Correct. Yes. Please assert.
We'll tell about the figures, my lord.
Yes. Yes.
Figures.
Please.
My lords, my respectful submission is that in respect of these institutions which have been established after 2nd June 2014, there can't be any legitimate demand from the students from state of Andhra Pradesh that you extend this also to us. My lords, in fact, even my friends have cited the decision of Honorable Justice, the division bench of this court, that is in relation to a super speciality course. My lords, the GO which has been issued is in tune and in consonance with the judgment also. My lord, the principle is
this thing. Yes.
That is met, my lords. In fact, the judgment of this honorable court, authored by Honorable Justice Rama Subramaniam, is also met, my lords. They are trying to distinguish that no, Section 95 has been interpreted. My lord, that is right. In those institutions, including the seats enhanced, 33 seats they will be competing in 20 institutions. And on account of the infrastructure which is developed by the state of Telangana and in the state of Telangana by other private institutions, my lords, 540, they will be competing in 540 seats also. My lords, sir, the very purpose and object of the carving out of the state of Telangana is, my lord, it suffered, my lord, serious setbacks in terms of politics, in terms of economics, in terms of education, in terms of employment. That is the prime objective. My lords, what is mandated by section 95 is, look, still everyone settles it, you provide whatever is available. My lords, that can never be allowed to be extended in respect of the institutions which have been established.
So section 95 doesn't apply to institutions.
Yes, my lords.
Which came into force after two.
My lords. This is as good as, my lord, a simple partition aspect, my lords. If something has been agreed by the parties to a partition to share a profit in the existing business, that is, my lords, as on 2nd June 2014 itself, what has been contained, what has been developed. Subsequently, the partition brothers, my lord, whether they will be entitled for a stake in the acquired property, which is after the division. Absolutely, there is no justification at all. My lord, sir, my respectful submission, the GO meets the requirement of the presidential order where the state of Telangana is entitled to have the complete, my lord, reservation in respect of the residences of the state of Telangana. In fact, my lords, the state of Andhra Pradesh also well understood. In fact, my lords, it was to maintain in some of the universities the proportion 15% to the state of Telangana also they like to maintain. In utter defiance to section 95, they have issued a GO, but I am not placing any reliance on that. My lords, my friends may not be justified in.
So then you please tell us how Pradeep Jain and that does not apply.
My lords, the state of Telangana enjoins the presidential order even now. The status of the special status conferred by the
which you said that subsequent decision has said that the ratio in Pradeep Jain will not apply to state of Telangana.
Pradeep Jain case, my lord, which deals with the reservation on the basis of residence, was impugned. My lords, Pradeep Jain case was distinguished with regard to the state which enjoins the special status under the presidential order. Therefore, with regard, my lords,
no, we want to come your comments on subsequent decision which you have referred to. 2016 volume 2 SCC 328.
Yes, my lord.
Please read it.
Yes, my lords. Para 30.
738.
36, my lord. 36 and 37.
Staple, madam, this is all loose pages. Stapler, no. Correct. Para 37.
36 and 37, I'll read, my lord, with these two.
This stapler.
We have referred to the aforesaid judgments in extenso as the Land Council.
Stapler. Bigger one. This small. Big stapler also is there, no? Big stapler is not there, slightly bigger. Big stapler is also slightly bigger. It's coming out, madam. Big, you don't have the stapler comes in only one size in here. Huh? Stapler, it's only one size here. No bigger. So do it, madam. That's what I'm saying. It's opening up because of it was stapled, but it's opening up. Get the big stapler. Yes.
My lord, para 36, my lord.
Para
36 and 37, my lord, relevant, my lords, very. An extensive study has been undertaken by the Honorable Supreme Court with regard to this, my lords. Para 36. We have referred to the aforesaid judgment in extenso as the learned counsel appearing for the petitioners have laid immense emphasis that there cannot be reservation of any kind in respect of postgraduate or super specialty courses. Regard being had to the law laid down by many judgments of this court, it is urged that the state of Andhra Pradesh and Telangana cannot apply the domicile test only to admit its own students, and that too also in respect of 15% quota meant for non-local candidates. We have already analyzed the factual score and the legal position. The undivided state of Andhra Pradesh enjoys a special privilege granted to it under Article 371D of the Constitution and the Presidential Order. The judgments of the larger bench do not refer to the said article, nor do they refer to the Presidential Order, but the said issue did not arise in the said cases. A scheme has been laid down in Pradeep Jain, and the concept of percentage has undergone certain changes. In Reita Nirankari, the same three-judge bench clarified the position which we have already reproduced herein before. However, in C. Surekha, the court had expressed its view about the amendment of the presidential order regard being had to the passage of time and the advancement in the state of Andhra Pradesh. It has been vehemently urged by Mr. So-and-so that despite 27 years having been elapsed, the situation remains the same. We take note of the said submission and we are also inclined to echo the observation that was made in Fazal Ghafoor, wherein it has been stated thus. In Pradeep Jain case, this court has observed that in super specialities there should really be no reservation. This is so in the general interest of the country and for improving the standards of higher education and thereby improving the quality of available medical services to the people of India. We hope and trust that the government of India and the state government shall seriously consider this aspect of the matter without delay, and appropriate guidelines shall be evolved by the Indian Medical Council so as to keep the super specialities in medical education unreserved, open and free. 37. The fond hope has remained in the sphere of hope, though there has been a progressive change. The said privilege remains unchanged, as if to compete with eternity. Therefore, we echo the same feeling and reiterate the aspirations of others so that the authorities can objectively assess and approach the situation so that the national interest can become paramount. We do not intend to add anything in this regard. Well, based on this observation in super specialty, reservations have been totally taken out as regards the super specialty in the medical education.
Yes.
My lords, the definition J subsection 2, my lord, section 2 of J, my lords, section 2, J, regard to successor state, my lord, in the presidential order, it referred to Andhra Pradesh. In the context of the president, same presidential order as to the state of Telangana, this definition, successor state, clause J of section 2, my lord, this successor state in relation to the existing.
Clause J of what?
My lord, Reorganization Act, my lord. I'm sorry. I'm sorry.
Reorganization Act.
Yes.
To J.
ఇదిగోండి ఇక్కడ తీసుకో. కోటా రెండు తీసుకో.
Lordship also needs a copy. You are not getting it. Your copy we have got.
My lords, to assist your lords.
We are surprised that they are unable to get even reorganization
They
act.
must be there, my lords, because it's reorganization act every day, my lords.
Every day, this is the roster, but they don't have it. What to say?
They must be there, my lords, but they're finding.
Yes. Yes.
J, my lord, successor state in relation to the existing state of Andhra Pradesh means the state of Andhra Pradesh or the state of Telangana, as the case may be.
Yes.
The presidential order, my lord, which referred to Andhra Pradesh as in 1974. My lords, now the same presidential order would apply as to the invocation.
We have understood that para 5, this amendment is in consonance with paragraph 5 and 6 of presidential order.
Yes.
Section 95 refers to the existing seats as on 2014.
Yes.
And this quota cannot have a reference to the future, this thing which
Yes,
may
my
be
lord.
accepted.
Absolutely, my lord. That is my respectful submission, my lords. In fact, my lords, this cannot be to the deprivation of the region, that is the state of Telangana. The challenge amounts to deprivation of the eligibility, the entitlement. And there can't be any legal logic at all, my lords, in the submissions of my friends at the bar that we also to be provided and extended with this 15% to them, half in the institutions after. I'm grateful, my lords, that this is my broader submissions in the case. Well, all the bar is also quite grateful. Your lordship has taken up the task of my lord, hearing this important issue on urgent basis. Obliged, my lords. My friend, Mr. Prabhakar Rao.
Mr. Rao. Yes.
Because your lordship may kindly record my appearance for the university as well as the state, my lords, along with Mr. Prabhakar Rao. Yes.
Please, lords. The petition is filed. The questioning GO, my lord. But the amendments brought to the military admission rules 2017.
Got the book, madam? Return their book, right? Yes.
The amendment, may I take again, my lord, lordships to the amendments, my lord.
Staple, big staple. You said it's not there. It's coming out. That's why I told. Yes.
WP, my lord, 24755.
So what are your submissions, Mr. Rao?
My submission to lordship says,
in addition to what has been argued by AG.
my submission to lordship says, my lord, that the intent and object of the presidential order is to provide equitable distribution of seats and among the 3 local areas. The lordship has dealt with the 3 local areas, my lord.
Yes.
Andhra University local area, Lord Usman University local area, and Lord Venkateswara University local area for your distribution. And Lord, as a date of Lord, the appointed date at 26/2014, Lord, the section 95 of the Reorganization Act says Lord, existing quotas shall continue.
Quota means existing quota.
Existing quota. Existing, my lord, as on the date of my lord 26/2000.
So you are maintaining existing quota.
Yes,
not
I'm
violating.
retaining existing quota, my lord, in the colleges, but established prior to 26/2014, my lord, including my lord, the enhanced seats in those colleges. As per the presidential order. That's may kindly see, my lord. All the petitions are hails from state of Andhra Pradesh. That's may kindly take my counter, my lord, vacate application counter. Page 44, my lord. The state of Andhra Pradesh issued a GO number 103, Health, Medical and Family Welfare Department dated 16/7/2023. Confining my lord 15% unreserved seats, excluding state of Telangana, to confining to seats Andhra University areas, Venkateshwara University area. Lakshmi, kindly see, my lord.
Andhra Pradesh provided 100% like you it provided.
Same, like same. For their candidates.
Including the petitioners.
Including petitioners. The petitioners availed the my lord, extra benefit of my lord, reserving my lord, the 100% reservation in favor of the local candidates. They filed a writ petition seeking admission into my lord, the.
So they availed of the benefit in Andhra Pradesh and now coming to Telangana.
They want to take back the, my lord, the seats of the Telangana people. Therefore, they are questioning my lord, the amendment brought to the, my lord, the admission rules 2017, stating that Section 95 of the Reorganization Act is applicable for another 10 years. Therefore, they are entitled, my lord, unreserved seats, they are entitled to compete, my lord, unreserved seats of 15%. That's two GOs they issued. GOs number 103 and also 104, that is in relation to, my lord, the postgraduate PG admissions, medical admissions.
Yes.
They issued two GOs, 103 for undergraduate.
Who they means who? Andhra Pradesh.
Andhra Pradesh government issued GOMS number 103. But in 16/7/2023.
Oh, whatever. So 100% they have also provided petitioner have availed of their with this thing, did not get admitted, now want to snatch the seats of Telangana people. That's
total three GOs they issued, my lord. 103, 104 and also 105.
So
my submission lordship says, my lord. Lord, reservation on the basis of domicile, my lord, is illegal according to them, my lord, as per the Pradeep Jain case. Pradeep Jain case has no application to the, my lord, the state of Telangana, state of Andhra Pradesh, as well as state of Kashmir, my lord.
Yes.
Jammu and Kashmir. As their two states are having a special provision in the constitution. Reserving 85% itself, my lord, is a contrary to the Pradeep Jain case. Itself is a Pradeep Jain. Therefore, these two states are exempted from the law laid down by the Pradeep Jain case by Supreme Court. It is clarified, my lord, in a Rita Nirankari case stating that there is a special provision. Therefore, the law laid down by that is not applicable to, my lord, those states. My lord, another two judgments they relied upon. My lord, that is. The Chebro Leela Prasadarao case. That is in relation to the employment in the scheduled areas.
That is 2023.
2021 11 SCC 401.
Relates to employment in scheduled area.
100% reservation. And another decision, Satyajit Kumar
Jharkhand.
That's the Jharkhand case. That is also in relation to the employer, not in relation to the admissions into the MBBS.
Employment. Article 14, 16.
Yes, sir. Right, Lordship, please to see, my lord. The presidential order, Lordship, kindly see the presidential order on bifurcation has to go as it is. The presidential order, the background behind, my lord, incorporate, bringing, my lord, the.
So you are also submitting that this thing, rules are in conformity with para 5 and 6 of presidential order, right?
Lord, rule 5, Lordship, kindly see, clause 5 says, Lord, para 5 says, 85% for local, 15% unreserved.
So that is in, you are saying consonance, amendment to the rule in consonance with presidential order.
No, not, Lordship, kindly see, that is applicable when the state of Andhra Pradesh is in force. Lord, presidential order is in force only, Lord, to the extent.
No, but presidential order applies to both. That's what argued by Advocate General. It applies to Andhra and Telangana both.
But before bifurcation, it is applicable presidential order. But existing, that is, since it is bifurcated.
So, are you saying that after bifurcation, presidential order does not apply?
95 applies. Section 95, Lord, extends.
No.
Existing quotas extends. That's why kindly see.
No, that you have submitted. We had noted down that section 95 refers to existing quota and cannot relate to any quota. But now, and Advocate General has argued that these amendments are in consonance with para 5 and 6 of the presidential order. That's what he has argued. You want to take a different stand?
Otherwise, we can't have reserve at all, my lord. 85. Otherwise, we can't reserve at all.
Talk to Mr. Rao.
Yes, Lord, I just.
Otherwise, we can't have 85%.
Small submission with regard to. Lord, Lordship, kindly see, Lord, as per the Pradeep Jain case, 15% of seats in Lord, the government colleges. Government colleges were contributed to central pool. Lord, the petitioners, Lord, the candidates of Lord, the other states also entitled to compete. But 15% of seats contributed by Lord, colleges from the state of Telangana. They are entitled. In addition to that, Lord, 15% of unreserved seats which in the colleges established prior to Lord, the 26-2014.
They are eligible. The only challenge is after 26-2014, you cannot have reservation on the 100% on the basis of domicile. That's the contention.
But therefore, my submission, Lordship says, Lord, same GOs they issue. Same GOs they issue.
Upheld by Andhra Pradesh High Court. SLP pending. This is what you, Mr. Rao, you are doing.
They challenge, but there is no interim order. The 2 rounds of counselling is already concluded there and here also.
So, Article 14 is not violated. You have also been lighter vein. Article 14 is not violated. You have held to.
That is the reason why my submission.
We are hearing you out of turn, Mr. This one devoting today.
I will take only 5 minutes. This only the object of the presidential order is to have equitable distribution.
That you have said one noted it down first submission.
Yes. One party takes away the seats of their own, exclusion of Telangana.
Bro, they have taken 100% seats of Andhra and want Telangana seats also.
Yes, sir. Yes.
Thank you, Mr. Rao. Please now 1 minute, Mr. Rao. He is a little jittery about making submission. Let him say what he wants to. Which WP number, Mr.
Sir. 1832-64.
1832-64.
32-64.
32
and 64. 64.
64. What?
My submission will have 2 aspects. One is calculations of the 85% confusion. Just I want to say only one thing. For example, 100 seats are their college. 15%.
Mr. Advocate General, give that figure. 1 minute. We will hear. Figure. Give us before conclusion, right?
Correct.
By next 15-20 minutes.
Yes.
Please.
For example, 100 seats are there in the college.
What you are giving example?
Example.
100%.
100 seats are existing in college, one college. Any medical college, for example. If the college is 100 seats, 100 total seating.
No, what is the submission first? Then we will go to example. What is the, by what do you want to prove by illustration?
All India quota is different from the 15% unreserved quota what we are claiming in institutions established after 2014. So there's a confusion.
All India
quota, 15% of all India quota.
All India quota of 15% is different from
15% quota, unreserved quota in colleges established after
15%. Unreserved quota
in colleges established after 2014. Or seats increased after 2014.
In colleges. No, there is no 15% quota for unreserved candidate in colleges after 2/6/2014.
That is what Geo says.
There is no quota.
No, there is not.
No, but you are saying there is a quota. That's why there is no quota. That's why you have challenged.
All India quota 15% central pool. That is different. That's why I'm taking example. 100 seats are there. 15 seats goes to all India quota. Remaining seats 85. Out of 85 seats, 15% goes to the unreserved category of local seats. That is 13 seats. It comes around 13 seats.
1 minute. We will note it down. So 15 seats goes to. I will say that he has illustrated by giving following example.
Yes, ma'am.
So you are supporting this, that all India quota of 15% is different from 15% unreserved quota in colleges.
Yes.
Right?
Right.
So your friend is feeling the heat. AC is not working, mister? Huh? Mr. Ranu, AC is not working in your room. Mr. Ranu?
Apologies, Your Lordships.
From your expression, we found out that probably AC is not working in your room. So we asked.
It's not about the AC, Your Lordships. That's a small clarification which I was.
Oh, what you will have? We will hear Mr. Rao and you later, but he was impatient.
I'm not impatient.
So therefore, we are hearing him first, so that he is satisfied and sits down quietly. So, 100 seats, so 15 seats go to where?
All India quota.
Then what happens to
85%? Out of 85%, 85 seats, 15% goes to unreserved category. That is
Where is
13
it?
seats.
Where is all this? Like you, it's not like you are demonstrating. It has to be rule. Where 15% goes where?
That is exactly what giving institutions established before 2014.
Where? So point out with reference to rules that 15% according to this rule prior to amendment it was required to go there. Where?
Same geo.
Which geo?
The impute geo.
Not impute. Prior to that, mister.
Prior to that also. That is 114.
Prior to that only.
Yes, 114 geo number 114.
How does it decide the question of validity of Rule 32H? 15% goes there, 5% remains here. Please tell us. Give his petition. Item number 18. 18. Let it go anywhere. We are not deciding what should go where. We are only deciding whether rule is intra-virus or ultra-virus.
My only submission is whatever situation existed before 2014, it established
has to prevail, right?
They must be continued to the.
No. See, if the petitions are allowed and the rule is struck down, automatically the position will prevail. And they will go, seat will go everywhere, wherever it has to go. If they don't go, seats, we are open 5 days a week.
Second aspect, APGOs, Millard. Second aspect, my government has raised. APGOs issued after issuing of this impute GO. Tit for tat. APGOs issued after issuance of this impute GO. After seeing the Telangana issued this GO, they have issued the same.
No, we are not going to decide that merely because Andhra issued, therefore Telangana is ultra vires, nothing. It's a legal issue. What has been argued by Mr. Rao, purely on legal issues, we will decide. Whether it is hit by Article 14, 16, 21, whatever 35 read with this thing, government has 16.3, government has power to frame rule violative of section 95. This not GO after did this did nothing. Validity of a provision cannot be decided who enacted first.
The council for the university stated that they are taking away seats.
We have to hear everyone. You can also, we are hearing you also. What to do?
Third point is, Milord, as per my judgments given by me, the two judgments given by me, the 2016 SCC online HYD 624 Milord, the Ramsur judgment. That
We have read it.
There is no answer as far as ratio laid down by the judgment, Milord. That is my assumption.
We will answer. No, don't answer. The court has to answer. You have a right to pose the query to court. Court has to answer in the judgment. And which is subject to Article 136 available to either parties. Then eventually Honorable Supreme Court answers the query.
My small request, Milord, you have to take my judgment, Milord, that is 2016. Otherwise, I will read out.
16.
2016.
This first round we did not permit you to read, so therefore you want to read. We want you
I
to.
will not read.
No.
1 minute, Milord. I will.
We will.
Judgment.
See, Mr. Our endeavor has always been nobody should feel that he has not been heard. So how does it matter? It will continue on Monday also. There's no problem. You argue.
I will not take much time. Only 1 minute. That's all. Just I want to show the relevant question.
Yes.
2016 SCC online HYD.
Hyderabad. Yes.
That's my para 21.
Existing admission quotas.
Yes, para 21.
Para 21.
Careful look at section 95 would show that both governments obliged to maintain existing admission quotas in all government, private, unaided institutions provided in Article 370 of the Constitution period of 10 years, during which the existing common admission process is to continue. The words, phrases are significant in section 95 that Recognition Act is all students in such state. The existing admission quotas.
Yes.
The significance my
existing quota. That's what Learned Advocate General argued.
Quotas.
That's what he's saying. Existing quota, we are not doing anything.
Existing quotas, even before established college, established before 2014. 2014 equally. Equally, that is my contention.
Section 95 applies to all. Like tomorrow, yesterday, institution may have come up. It applies to them also.
Them also.
Yes.
Till 2nd June 2024. That's it. So it clear this the judgment. There is no contradiction to the judgment from the statement. That's my submission.
Anything else? Thank you. Mr. Rao.
To simplify things,
please brief. 1 minute. Please be brief.
Yes.
And this thing.
But to simplify things, a preamble could have been to the GO, spelling out the intent for introducing that GO. Because to avoid this confusion, understanding the impact and the sum and substance effect of that GO.
That's why
there is no intent.
No. That's why courts are meant to interpret and clarify.
Remotely alien.
1 minute. So therefore it is clear that the challenge is confined to 85% of seats insofar as it provide 100% reservation on domicile. Everything you have argued very well, Mr. Rao. What else?
Just one. The Dr. Sandeep's case, my lord. I'll just take your lordships to the first paragraph and
yes, Sandeep.
This is a case which arose under
1 minute
seeking.
1 minute. We'll see Sandeep. Kumar, Sandeep, Sandeep.
Dr. Sandeep.
Sandeep, no, not the doctor.
2000.
Sandeep and others.
Yes.
2016 to SCC.
Yes.
328.
First paragraph.
First paragraph. Yes.
The gravamen of grievance and substratum of discontent of petitioners in this writ petition preferred under Article 30.
To state of AP, Telangana and Tamil Nadu. Right.
And
So
when the
in
judge-
that context,
Yes.
Supreme Court, what according to you it said?
The last paragraph.
Last.
37.
37. Yes.
Para.
Fond and hope. No, para 36 you must read.
Yes.
Also, my God shows some light. My friend is arguing this, therefore, there are other
I'll read para 19. Paragraph 19.
Please read para
Hello.
19 also. Yes.
Hello. In Dr. Pradeep Jain, a three-judge bench was dealing with. Pradeep Jain is purely on
No,
undergraduate case.
Para 19.
Para 19 minute. In Dr. Pradeep Jain, a three-judge
No. That's the problem. You are having live law or something. We are having SCC. He has given SCC citation, right, Mr. Advocate General? You are relying on SCC citation.
Yes, ma'am. Yes.
Para 19.
I'm sorry.
That's right.
After the said judgment was delivered, the said three-judge bench passed a clarificatory order in Rita Nirankari, wherein the court considered three aspects, one of which is relevant for the present case. We reproduce the same. We may make it clear that the judgment will not apply to the states of Andhra Pradesh and Jammu and Kashmir because at the time of hearing of the main writ petitions, it was pointed out to us by the learned advocates appearing on behalf of those states that there was a special constitutional provisions in regard to them which would need independent consideration by this court. I'll just make it, but pausing here, my lord. A small matter.
So, 1 minute. So, what you are saying is that this Sandeep's case does not apply to Madhya Pradesh.
Yes, this fact would be relevant.
To state of Telangana.
Yes, this fact would be relevant. When this case was being heard and considered, my lord, states of Andhra Pradesh and Telangana did not start contributing to the All India quota. We started contributing to the All India quota from the academic year 2018. Because of the decisions of the Honorable Supreme Court, we had a now uniform contribution. This is of 2015 year. This is decided in 2015, though it is reported in 2016.
It's 27.
Decided, yes, we never contributed. States of Telangana and Andhra Pradesh never contributed to the All India quota pool as on that date. We started contributing from 2018 onwards. Therefore, this complaint before the Honorable Supreme Court. All these candidates approached the Supreme Court. And
So, your submission is 2016 does not apply.
Yes.
All right. Then what else?
But just one more reply, my lord. My lord, the argument that shift in arrangement 2014, the timeline is 2014. The shift in arrangement is there. It's a matter of fact. The shift in arrangement is section 95. They wanted to continue for a period of 10 years. Yet they continued the practice till 9 years. They never tinkered with that practice. Now is the year which the government felt, yes, now is the appropriate time. There is no intent. There is no, while amending a rule, a crucial rule which describes an eligibility criteria, the government could have, as a preamble or as a pretext, could have spelled out an intent. Why lose? Why not in the past 9 years, and why only this year?
So while amending the rule, the preamble should have been attached.
Generally, well, in general, every.
So therefore, it is struck down. Liable to be no preamble, liable to be struck down. Or it was an advisable course of action.
No, my lord.
That we cannot recommend to legislature.
I'm just saying the arrangement continued for 9 years.
That's correct.
Arrangement continued for 9 years, and the last year they
continued for 9 years. So no justification for making a departure this year, which is the last year.
Yes, this is the last year,
and therefore, in any case, after this year, rules of the game are going to be changed. Correct to what you have argued. Sequent to that. Correct. You can smile at least, Mr. Rao. There's nothing.
This kind of prompting.
No justification for changing it in the last year. All right, correct.
Some premonition notion alerted to the government. Maybe they saw some light. Next year, something could have happened. So therefore, this year they started there.
Oh. What else?
My lord, in the matter of facts, my lord, even before subject to correction, the seat arrangement, seat matrix, and the percentages and all. Well, in a safe way, I'll go with the standing council, my lord. Whatever learned standing council submits in that regard, because he's been there for a very long time. Mr. Prabhakar, University Standing Council.
Not there for the long time. He has left the quota.
Well, and I missed being in the good books. He is not here. I made such a.
No. No, what, so he is there for long, so how does it help?
Yes, being there for a long time, he will be able to, my lord, clarify the position regarding the percentages, the seat
Hey,
matrix.
Mr. Advocate General has made a statement that binds, we are going to say that. What, Mr.?
Because now the difficulty is, my lord, the seat matrix is there for your lordships to examine. In the
No,
seat
nothing. Sorry. That is not seat matrix, is not the subject matter. Again, we will invite your attention to the read petition.
Only to counter.
No.
Only to substantiate, my lord. I'm not saying.
Mr. Prayer, see, read page 22.
Nothing against that, my lord.
No. Read your prayer, page 22. Please read. There is no, this is all, I mean, like pushing on things, passing the buck. We will not permit. We will record this. We asked upon the council to read para 22. Page 22, what is the petition? There is no prayer for examination of seat matrix. We are called upon to examine the validity of rule as we understand. Please tell us, where have you questioned the matrix and all that?
In order to, my lord, substantiate that argument, if the seat matrix can be looked into,
No, we can't.
this will be clarified.
Mr. We will not travel beyond the scope of the writ petition so as to give a ground to anybody that court has traveled beyond the scope. You know it, Mr.
Yes.
You have not given it in written submission also. Don't like that this thing that I argued court did not answer.
No, I was conscious, my lord. I was conscious not.
No, you have not made it in your written submissions also. We will not permit anything. Yes, that's it, Mr. Rao.
Yes.
Thank you. Yes. Mr. Yes.
Your lordships, with
AC is working. Air condition is working, no?
Yes, your lordships.
No. Yes. Yes,
Lordships,
please.
with respect to the seat matrix, if I can request your lordship's attention to item number 41 file, your lordships.
No, Mr. Then your cases will be delinked from the bunch. We are only in this case examining the validity of a rule. And you said so.
I am only referring to that particular document just to state, your lordships, the submission made by the learned AG stating that the reservation is only with respect to 85% and not 100%. The seat matrix, your lordships, doesn't say so. All the seats that are...
Mr. Once we don't know, once whatever has been argued and is recorded by us in the order, his submission will be recorded. So, seat matrix will have to be given effect to altered accordingly. It cannot remain like this. You understand?
Obliged, lordships, obliged.
This is Mr. Advocate General, correct? Any variance between the seat matrix and the statement made by you, the seat matrix has to be altered in consonance with your statement in the sense that reservation of 100% domicile is provided only in respect of 85% seats and remaining 15% all India quota, 27 state plus students of Andhra Pradesh are at liberty.
Yes, ma'am.
Obliged, lordships. I rest my case. I'm really grateful.
I missed
your
two.
lordships
I'm
have
sorry, my lords. One aspect, my lords, where they were harping on some judgments where after the game has begun. My lords, as far as the notification issued by the Health University is on 6th July 23. Inviting, my lords, 6th July 23 is the notification issued by the Health University. My lord, the GO is of 3rd July 23.
3rd July and 6th July is the
notification from inviting, my lords, eligible applicants who have qualified in the NEET exam. The NEET exam has nothing to do with this. Right. My lords, your lordship may also kindly take section 97, my lord, of the Reorganization Act. Section 97 of the AP Reorganization Act. Amendment of Article 371D of the Constitution. Also, on and from the appointed day in Article 371D of the Constitution. In the marginal heading for the words the state of Andhra Pradesh, the words the state of Andhra Pradesh or the state of Telangana shall be substituted. That's why I am saying is, my lords, presidential order would apply as far as the invocation of this 85%, that is 100% of the local reservation, is within the domain of the states, respective states. My lords, I am obliged.
But need.
So 1 minute. So Mr. AG, once again we are asking you that this seat matrix has to be in conformity with what you have said. That reservation is, Mr. Reservation is in respect of 85% of seats, right? 15% you cannot touch. That is all India.
Yes.
In respect of 85% seats, you are provided 100% reservation. If there is any variation in the seat matrix, then it will be set right. If there is any variation. If there is any variation. Right.
University oversees the logistics, my lord, logistics parts of the counseling. NEET is the exam is the, my lord, relevant date for the start of the academic year. That's how I insisted, my lord. I highlighted that start of that date.
We are not giving a finding whether seat matrix is in variance or not. As we told you, Mr.
The rule after the game, but university has no role to play in the common entrance conducted by All India. NEET. It is the NEET national.
That's what learned advocate general is arguing, that there. No.
Only for.
That's what he's arguing, that the so far as Andhra Pradesh is Telangana is concerned, the game begins on 6th of July.
Yes.
And before that,
Everybody competes. All over India compete.
1 minute.
15% they can come.
Mr. What about that? This figures.
Figures, my lords, will just pass on. My friend has brought.
So, how many total number of seats?
Just calculate in university. There is a calculation going on.
No, so calculate. So, you see, only we wanted a figure.
That's first.
That we only to this thing. He is submitting part of submission. That out of supposing 815 are total number of seats.
Yes.
Out of them, 85% means 6982 are for Telangana. 15%, that is 1232, are all India seats in which candidates of all other states and union territories, including state of Andhra Pradesh, can participate.
But the figures, my lord, correct figures, my friend will pass on.
So like this is
yes
your submission, so we want to record this by giving correct figures. So please pass it on, Mr. Rao, to date, sir. Mark the yes, Mr. Rao. Anything else?
One submission info.
So submissions of learned C. Formal party. You will also have.
You are supporting. You are supporting. In support the GO. Yes, my lord.
All right. We will record this.
It's mutely.
Everybody mark the presence. Arguments concluded. Reserved for delivery of judgment.
But item 19, my lord.
You said different case. Some other day. Every day we cannot devote time, right? There was a day when we made exception and made everybody else. Every day cannot be this thing. It will be heard whenever it comes.
This request whenever it's suitable.
No? We thought it's the same case. Item 19. Mark the presence on account of paucity of time. The matter could not be taken up. List on 13/9/2023. What is in that case? Different?
Same PG admissions, there's a separate geo, same in the same lines, same 100%.
So then why should you this thing defer it?
I did not want to insist on the challenge, my lord, because if I'm considered on the local, my lord, I'll be serving the state.
We don't know.
For the next 10 years, I'll be serving the state. I'm tied up by the bond condition. I'm already in the my lord, grade.
No, what they want is that the candidates that we don't know.
Your lordship's judgment covers me, my lord. If they have that benevolent, my lord, I can just.
Mr. Rao is very magnanimous in our approach. No. Mr. Rao is very magnanimous in his approach. You take advantage of tomorrow's holiday and convince him. He may say, but we will permit you to serve the state of Telangana for 10 years. We don't know. But so far as we are concerned, we will have to go by the legality part of it. That is the problem. We are bound by law. Reserved food.
Great tubular structures.
Huh? 1 minute. Yes. Not come. See, Mr. Advocate General, today a mention was made for extension of interim order, right? We granted the lunch motion. It has been passed over. And the name is being reflected in the system that he is requested to appear. You tell us, as leader of the bar, what should we do? It appears that we want extension of interim order, right? Council is not bothered. His job is 10:30. He came and disappeared.
I'm sorry,
Right, none for the petitioner, even though the matter is listed.